Okay, let's do it.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everybody. Welcome to the Appeals Court. We are, of course, sitting by video conference due to the ongoing pandemic. I am Justice Rubin. I am joined today by my colleagues, Justices Kinder and Ditkoff. We will be hearing 6 cases this morning, the first one of which is Commonwealth versus Lawrence, number 21-141. The rules of argument when we hear them by video conference are the same as the rules in our courtroom, which is to say 15 minutes per side, and there is no rebuttal. And we will hear first from you, Attorney Cowie McDermott.
Good morning. Thank you. May it please the court. My name is Diana Cowie McDermott, and I represent the defendant in this matter. The defendant was convicted of 2 counts of child pornography. These stem from 2 emails that the defendant allegedly authored and sent to himself. He downloaded child pornography and sent that child pornography back to his own email account. At trial, the Commonwealth produced 4 records: Comcast, T-Mobile, Microsoft, and a cyber tip report from a national center for missing and exploited children. The Commonwealth sought to introduce these records pursuant to the business record hearsay exception 233, section 78, which requires the proponent to introduce records, 1, that were made in good faith, 2, that were made in the regular course of business, 3, that were made prior to any legal proceedings, and 4, it was the regular course of the business to make such records. At best, prongs 2 and 3 have been met in this case. Custodians for each business did testify. Absent evidence to the contrary, when a judge admits a business record, the court will imply that the foundational requirements have been met. But I would ask this court not to make such an implication. As to the good faith requirement, the Commonwealth represented that none of the witnesses had viewed the attached photos of the child pornography in this case. So we have witnesses that testified without actually seeing the records themselves. Also in Commonwealth v. Gray, there the Commonwealth sought to introduce a business record. The Commonwealth did not offer any of the foundational requirements pursuant to 78. The court nonetheless admitted that what was called a booking memo as a business record and also as a statement against a party opponent. But on appeal, the court found that since none of the foundational requirements were met, the record was admitted in error. This is a situation where we have multiple sources of information. The Commonwealth's record, the Microsoft records, as well as the cyber tip, particularly relate to this multiple source. So we have the defendant who is allegedly the author of 2 emails. Then we have the photo DNA software, which is a software created by Microsoft for the purpose of detecting, quote, known child pornography. This software intercepted the defendant's email that he sent to himself and stopped it. When the Microsoft intercepted the email, Microsoft then sent a report up to this national center. The custodian from Microsoft testified that she did not fill out that report. There was no evidence as to who filled out that report. The center upon
I'm sorry, I thought the testimony was that it was automated.
I'm sorry, that the testimony was what?
That it was automated. That it was an automated process, that it was automatic.
Yes, that's right. But who pushed the button? There was no
If
testimony.
it's automatic, I don't understand what difference it makes. Someone from the company says, we have an automated system here. When the checksum matches the digital fingerprint or whatever it is, footprint of the particular items, they're forwarded to this place. What is it? I mean, let's say that system was set up 8 years ago. No one who works there now still works there. Someone from the company comes in and says, this is what we set up and this is how it works. Why do you need to know in order for it to be authenticated? I mean, I understand, right? I mean, this all might be grist for cross-examination or challenge. We're just talking about authentication of the item. What is it that you were saying is unknown that is necessary for there to be sufficient evidence for this to be authenticated?
Because the testimony came out that this software will detect what is known as, quote, known child pornography. And the testimony came out that law enforcement, we don't know which law enforcement, some law enforcement agency has determined that some material, don't know why or under what circumstances, is child pornography. And when these known child pornography images appear on the internet, then this Microsoft photo DNA software will interfere and
we're just talking about authenticating it as what it is supposed to be, which is an email. That doesn't prove it's child pornography. Of course, these photos were shown to the jury, and that's a separate issue that we may get to. But authenticating them as what they purport to be, which is an attachment to an email that triggered the photo DNA software and was then forwarded to the center for whatever it's called. Why isn't there sufficient evidence? And there only has to be, if I'm not mistaken, sufficient evidence to support a finding that that is what this is. Why isn't the Microsoft representative's testimony adequate to authenticate it to that extent? I'm not saying to say it is child pornography or it was actually sent by your client or anything, just that here's this thing.
I understand. And I think my response is that the statute requires the proponent to offer evidence that the records were made in good faith. And none of the witnesses testified that the records were made in good faith. None of the witnesses viewed the records to say these were made in good faith.
I'm sorry, I don't understand what that means. How would viewing them? All right, so now an email is sent to the center. And in fact, someone there does, I think maybe they just forward it without even opening it. I have no idea. Someone looks at it and says, oh, goodness, yeah, this should be referred to law enforcement. I guess I don't understand. What is what does in good faith mean? It's an automated system that was set up. Now, if you're saying that it was, I guess I just don't understand what.
I think I understand. I think, unless I'm repeating myself, I think my point, though, is that these 4 foundational requirements must be found. The proponent must show evidence that the records were made in good faith. That's the first one. You don't think
a juror, having listened to this person from Microsoft, could conclude, oh, I guess they put in place some kind of a system to try to track child pornography and catch people who were distributing it? I guess they did that in good faith. Now, maybe it's not being operated in good faith. Maybe law enforcement people have put some fake data in or something, and it's wrongfully sending emails to the Center for Exploited Children and catching people in a dragnet that really isn't about child pornography. But all they have to demonstrate, I would have thought, is that the system they set up was set up in good faith. And I'm not sure why that isn't a reasonable inference that you could draw from hearing it described.
Because it's the records themselves were made in good faith, and there just was no evidence to that. And the statute provides.
I'm sorry, the record we're talking about that you're concerned about is the email sent to the center, the one created by the photo DNA software?
Sent to the center through Microsoft. That's
So
correct.
how could that be not, I don't understand when you say not in good faith. If they set up a system in good faith.
It's
All right.
not that the system should be created in good faith. It's that the actual record should be made in good faith. The statute requires that the proponent produce evidence that the records that they seek to introduce were made in good faith. And the custodians in this case only testified to prongs 2 and 3. There was no evidence that custodian could offer showing by a preponderance of the evidence that the records were made in good faith. They did not look at the records. They contained the child pornography. The Commonwealth represented that the custodians did not want to look at the records because of the child pornography.
Doesn't that suggest that they were acting in good faith?
I respectfully suggest no, that the good faith proponent aspect goes to the maker made the records in good faith.
Counsel, is there any authority for the proposition that in order to reach that good faith evidentiary threshold, someone has to have testified that they were created in good faith?
Yes, the statute provides that the proponent must produce evidence sufficient by a preponderance of the evidence to show that the record was made in good faith. And after the court makes those 4 preliminary findings, the court then will allow the jury to consider that evidence and to evaluate those records and assign whatever weight the jury chooses to. But the statute requires that the court first make this finding based on evidence produced satisfying the 4 prongs. And after the court makes that determination that these 4 prongs have been satisfied, then the court will instruct the jury that they may consider these business records and assign whatever weight it chooses to, as long as the jury finds those 4 prongs. The jury too must find those 4 prongs, not for the purpose of determining whether or not the records are admissible, but whether or not the jury wishes to assign any weight to the records. So it's
couldn't we conclude that those findings, if required, were implicit since the judge admitted the evidence?
Yes, the court can. And the case law says that when a court admits a record under the hearsay exception, this court can imply that the 4 foundational requirements were met, absent evidence to the contrary. So I'm asking this court to not apply that implication, not to imply that the 4 prongs were made, because there was no evidence of this good faith. And the evidence to the contrary is that Commonwealth's representation that none of the witnesses viewed the records because they contained child pornography and they were disturbing. So we don't have evidence by a preponderance of the evidence that the custodians viewed the records, and therefore we can't say that they were made in good faith. Even if the court—
Counselor, only 2 of the exhibits actually contained child pornography.
Correct.
So is your argument only to exhibits 3 and 4?
Essentially, yes. As to the business record exception, yes. To the Microsoft records and to the cyber tip report. My argument as to the records being admitted under the hearsay exception rule apply largely to those 2 records. As to authenticate—
Do you have any objection that you're raising now to exhibits 1 and 2?
As to authentication, yes.
And
They
what
should
is,
not,
what is that? Please explain that if it's not business records. Just for exhibit 1 and 2.
okay, and what was the court's question then?
You say you have an objection to exhibits 1 and 2, and you've already said it isn't business records. So what is your problem with exhibits 1 and 2 at this stage?
With 1 and 2, that being, I forget what number they're labeled to.
The T-Mobile records and the Comcast
Okay.
records. There's no
Okay.
emails in them. It's all IP addresses and subscriber information.
Yeah, so the Microsoft record and the cyber tip report, my argument that they are business records not satisfying the hearsay exception applies largely to those 2 records. These 2 records include multiple sources.
You're almost out of time, so I'll ask you one more time. If you've got an objection at this stage to exhibits 1 and 2, you need to tell me what it is now, or I'm going to assume you don't have a problem with them.
And maybe I misunderstood, so I missed it. I apologize. Are those 2 records that you're referring to, 1 and 2, the Microsoft and the cyber tip report?
No, that's T-Mobile records and the Comcast records.
Okay, I'm sorry. So
Maybe you don't have an issue with them. I just need to know because we got
only as to authentication,
And what's your
If this-
authentication? What's your authentication problem with 1 and 2?
that there was no evidence of good faith.
Okay,
The hearsay
Got it.
exception applies largely to the Microsoft records and the cyber tip because we're in a situation where there's multiple sources. The Commonwealth was required to prove that each source of information had a duty to report. And the Commonwealth did not establish that in this case.
why do you need a duty to report? I thought you just need kept in the ordinary course of business.
No, according to Wingate, when we have multiple levels of sources of information, each level of communication must satisfy the business record hearsay exception, including that they were under, that the source was under a duty to produce records in order for them to be admissible. So for the Commonwealth in this case to rely on Microsoft records and the cyber tip report records, the Commonwealth was required to produce to show that each level of communication satisfied the business record hearsay exception, the 4 prongs, and they did not do so in this case. So as I say, the first level being the defendant, and then the second level being the software intercepting the records, sending the report up to the National Center, the center relying on the Microsoft's records, and then the center creating their own record themselves. We have multiple layers, and pursuant to Wingate.
Let me ask you one more question since your time's over. The exhibits you put in your appendix, except for the images, is that the complete exhibits?
Yes, that's my understanding.
Okay.
I know the Commonwealth supplemented, but yes, the record appendix, I believe, is in its entirety.
Thank you.
Okay, your time has expired. Thank you very much. Very good
Thank you.
argument. We will hear now from Attorney Palumbo.
May it please the court, Karen Palumbo for the Commonwealth. First, as far as the business record exception to the hearsay rule, I would suggest that the Commonwealth presented sufficient evidence through the testimony of a representative from Microsoft, T-Mobile, Comcast, and NCMEC, which is the National Center for Missing and Exploited Children. Each witness testified that the records were kept electronically in the ordinary course of business. They were created contemporaneously, and they were not created in anticipation of litigation. No witness actually spoke the words good faith, but business records can be presumed to be reliable and made in good faith because the entries in the records are routinely made by those charged with the responsibility of making accurate entries and are relied on in the course of doing business. And that's Commonwealth v. Sin Van Tran, 460 Mass 535. I'd like to address the confirming circumstances for the court. Defendant filed two motions in limine pretrial. The second motion asked the court to preclude the admission of hearsay evidence, the emails and attachments, absent authentication, i.e. that the defendant drafted the emails. The requirement is that the judge act as a gatekeeper and preliminary determine that whether the evidence, if believed, is sufficient for a reasonable jury to, by a preponderance of the evidence, that the defendant authored the emails. I would suggest in this case, there was sufficient evidence that the defendant authored the emails. In addition to the emails having originated from his account, an account bearing his name and acknowledged to be used by the defendant, the address of the account was located at 61 Witchwood Road. The defendant admitted that he lived at 61 Witchwood Road. The defendant also admitted that he had a phone through T-Mobile and that at that time he used the email address jameslawrence8@msn.com. His ex-girlfriend testified that she lived at 61 Witchwood Road with the defendant and the defendant's daughter, and at that time they had a family.
I'm sorry, he admitted that he used this email account around the dates of,
He didn't say he used on those particular dates.
Okay.
He said that was my account and I used it at that time. He
What
did
is
not
at
admit.
that, why are you saying at that time? I thought that his position was that he no longer used the email.
Yeah, he did. So it was in June of 2016, I believe, when the officers spoke with him. And the delay was because of the course of the investigation, getting the subpoenas took quite some time. So at that point, he said he used to use, that was his account at that time frame, during that time frame. And he used
Why are you
it.
saying during that time frame? I'm sorry, I don't understand. I don't think that he admitted that he used that email account around the time that these emails were sent, right?
He said it was his email. He used that email at the time. I haven't.
He keeps using the phrase "at the time." What do you mean? I thought it was something he claimed no longer to use.
Correct, but that was in 2016. The emails that were offensive and that were the email that was found by NCMEC, Microsoft through the photo DNA, and NCMEC was February 8th of 2015. The other offending emails were sent on December 13th of 2015, 9 emails.
Mm-hmm.
The officers are speaking with him in June of 2016. So he said at the time.
You're saying he admitted that in February and December of 2015, he was actively using that email account?
He didn't say in February and in December, but he said at the time, I believe it's at transcript 1, 12 to 13.
Okay, I'll have to look. I don't understand what you mean at the time.
Sorry, what was that? What was that transcript?
Transcript 1 at 12 to 13. I think he meant previously I did use that account.
Well, of course, previously he used the account, but I didn't think that I thought that your case that he was the person who sent the email relied in part on the fact that he was still receiving emails at that address from his daughter's school.
No.
Not on his admission. No?
So the defendant received the first email, as I said, was February 8th, 2015. And that was the email that the photo DNA caught sent to NCMEC. NCMEC provides that information to law enforcement in the appropriate region. Then law enforcement begins by getting subpoenas. When they got subpoenas and they subpoenaed the information from Mr. Lawrence's MSN account, they found 9 additional emails with child pornography. Those 9 emails were sent on December 13th from James Lawrence at 8msn.com to James Lawrence at 8msn.com. Prior to that, on December 8th, there were 2 emails. One was sent to the defendant regarding his daughter, and one was CC'd to him regarding his daughter. On the 11th, the defendant logged. At this point, the defendant no longer had internet and had to use various neighbors' Wi-Fi to access the internet.
Okay, I think I understand that. There are no other emails that were sent from this account. There were some received, but no, you have no evidence of any other emails sent from this account at or around the time of the child pornography, right?
No, we just have evidence that emails were received that were personal to the defendant.
That's fine.
Okay.
Counselor, do we have, other than the images, do we have the complete exhibits?
I don't believe you do. I didn't request them from the court, and the exhibits I provided were the emails that were around the time of December 11th, and I was attempting to show that he had continuous control over the account.
Do you
And that
not
the
have,
account was in fact his account.
do you not have the exhibits anymore?
They would be in the clerk's office.
The Commonwealth did not keep a copy of these records?
They're
Really?
not in the order they were admitted in the clerk's office. And I think it's one big file, and it includes the offending photographs.
Let me ask you this. Your colleague, Attorney Cowie McDermott, argues that the photographs that were shown to the jury were egregious, and the risk of unfair prejudice substantially outweighed their probative value. What's your response to that?
I disagree, Your Honor. Whether evidence is more prejudicial than probative is for the discretion of the trial judge. And simply because a photograph is gruesome or inflammatory does not mean it should be excluded. It's whether the photograph has evidentiary value. And here the photographs.
So regardless of how gruesome something is, if it has evidential value, it can come in?
Well, that's where the judge exercises his discretion.
Do you agree that at some point something can be so offensive or egregious that it would be an abuse of discretion to admit it?
At some point, but in a child pornography case where two of the elements are, were the pictures of child pornography, and was the defendant aware of the nature of the pictures, I would suggest it would have to be a pretty egregious picture to rise to the level of an abuse.
But you think there are some pictures that would be so egregious of child pornography that it might be an abuse of discretion to admit them, or you think by definition they are all admissible?
That's a tricky question because it goes directly to two elements of the crime charge, and the Commonwealth is entitled to and offer all probative evidence as far as their elements.
So you think it could not have been an abuse of discretion regardless of what these photos look like?
Well,
to put them in?
I wouldn't say it couldn't be, but I would say in this case, it was not an abuse of discretion.
How are we supposed to know?
Oh, because you don't have the photographs?
You thought they were so egregious that we couldn't see them.
Well, I didn't see them either.
So how do you know that there wasn't an abuse of discretion? I find that very odd.
Okay.
You haven't seen the evidence? You're the lawyer for the Commonwealth.
All right, I didn't look at the photos.
So how do you know it wasn't an abuse of discretion to admit them? How can you even make a good faith argument?
They're an element of the crime charge, so I feel like they were properly
Well, but
admitted.
you just told me that it's not a per se rule that you have to, that something could be so egregious. All we know about them is that someone wept openly upon seeing the first one. That's all we know about this evidence. You haven't even looked at it.
I have not looked at them.
Well, how are we supposed to assess whether there was an abuse of discretion? How are you even surprised? I'm very surprised to hear that.
As regards to the juror who wept, I would suggest that the judge.
I'm not asking about the juror's
Okay.
fairness. I'm asking about the admissibility of these pictures.
And again, Your Honor, I would suggest that they are admissible. I didn't review them.
How
but
can
the
you
judge
tell me
reviewed
that?
them.
You haven't seen them. You don't know. I mean, if there's something that's so terrible it couldn't be admitted, how do you know this isn't one of those things?
I guess I don't know, Your Honor. Would
Okay.
the court like me to forward those exhibits to the court?
Yes,
So that
your
you may-
decision. You're the lawyer here. We're not. I'm very surprised you haven't seen the evidence, and yet you're arguing it's not an abuse of discretion. That's very. I don't understand how you can. It's very bizarre to me.
Well, I will file a motion with the court to admit the entire exhibits from the clerk's office, if that's okay with the court.
Do you think you should review them first to figure out whether it might have been an abuse of discretion to admit
I
them?
will, Your Honor, yes. But I still believe in a child pornography case where it goes directly to two elements of the crime charge that those photographs were properly admitted.
Well, maybe.
Your Honor mentioned the juror who was teary-eyed or crying when she saw the pictures. The judge did speak with the juror, and that's at transcript 2 at 98 to 104. The juror did say that the photos were disturbing and that she has a 10-year-old daughter, but
Can I ask you? it said that when she looked at the first photo is when she wept. Is the first photo this collage where a stipulation was offered? Is that the one?
Yes,
So the
that
one
is.
that she wept about and asked the judge later, why would you let this be shown in court? That one is the one that the defendant said, we will stipulate that it's child pornography,
Yes.
but don't let it in. Okay.
But the defendant in his brief, just to inform the court, suggests that he's agreed to stipulate to all 10 photographs. And that
No,
was
I
not the case.
understand. I looked and that's not right. But with that
Okay.
one,
All right. So the judge spoke with
and to be clear, I appreciate you're not wanting to look at these photos. I have no interest in looking at them either, but the jury had to look at them,
Mhm.
right?
I
And
apologize.
the judge, I assume, before letting them in, had to look at them
Yes.
to figure out whether they were permissible or not. That's all I'm saying.
Okay, I understand, Your Honor. Thank you. The judge spoke with the juror, and toward the end, he asked her, would you still be able to deliberate and consider all the evidence and make a decision based on the evidence you find credible in the law that I instruct you? The juror said, definitely. I would suggest that the defendant claims the juror could not state unequivocally that she could be impartial, and I would suggest that the juror did state unequivocally that she could be impartial. And the court gives great deference to trial judges where a determination of the juror's impartiality is basically one of credibility. Also, the defendant cites no cases or authorities to support his argument that the judge abused his discretion. Would the court like me to address the instruction?
Your time is yours.
Okay, the instruction the defendant requested, which is at SA Supplemental Appendix at 23, and the instruction that the judge gave is almost word for word exact, except the defendant requested there must be some confirming circumstances sufficient for reasonable jury. And the judge in the instructions stated there must be some confirming circumstances sufficient for you when he was speaking to the jury. And I would suggest that did not rise to the level of substantial risk of a miscarriage of justice. Again, defendant did not object at the time, suggesting he was either happy with the instruction, and also he deprived the judge of an opportunity to correct it if there were an error. But I would suggest that there was no substantial risk of miscarriage of justice and that instruction was proper. If there are no further questions.
I see none.
All right, I will file a motion to enlarge the record and submit those to the court.
Thank you for your argument.
Wait, hold on, counsel, a motion to transmit the exhibits from the clerk's
Yes.
office?
Yes. Well, do I need to file? Oh, yes, that's what I'll do.
Okay.
The case is now being recorded.
Good morning and welcome to the Appeals Court. Our session this morning continues with number 20-1203 Commonwealth versus CRANSHAWN. I am Justice Rubin. I'm joined today by Justices Kinder and Ditkoff. The rules for oral argument when we do it by video conference, as we are today due to the ongoing pandemic, are the same as in our courtroom, 15 minutes per side, and there is no rebuttal. And we will hear first from Attorney O'Brien.
Thank you. Good morning, Your Honors. So Mr. Cranshaw's case, the appeal in this matter centers, as you know, on sort of the question of what to do during jury impanelment with prospective jurors who at some point during the impanelment communicate that they would have trouble coming to a fair verdict if they did not hear testimony from the defendant.
Can I stop you there?
Absolutely.
I stop you there? That isn't quite what they said, is it? Didn't they say in response to a hypothetical posed by defense counsel that they would expect in certain circumstances a defendant to testify?
Yes, Judge. Yes, I think you're right. I think I put a little bit of
Okay.
my own. I put my own arguments in there a little bit, but
All right.
yes,
Well, let me,
that they would
as long
expect
as
him to
we're on this
testify if he
point,
was innocent.
Then
Yes.
can I ask you just to follow up quickly, and then I'll
Yes.
let you go.
No, go ahead.
Would you agree that there's a difference between an expectation that a defendant might testify in certain circumstances and an understanding of the fact that he has no obligation to do so?
Yes.
Okay. Now I interrupted, so you can proceed.
No, interrupt anytime, Judge. So correct. I think generally speaking, the three prospective jurors that I focused on here, I understand the hypothetical that the trial attorney threw out there, but notwithstanding the hypothetical, I think the problem here was that these were three jurors who said that they would expect him to testify, and I'm using my own words here, but if he had nothing to hide, if he was, per se innocent.
Okay, but let's say I were to agree with you that at least two of these jurors, one of them says, well, look, that's his right. I mean, I haven't seen a voir dire like this. It seems like a free-for-all. I don't know what was going on, but there we have it, right? So they say these things. Let's say that they warranted dismissal for cause. I may be mistaken, but my reading of the case law is that if the defendant who had peremptories available at the time didn't strike them with the peremptories and then run out, that you can't show prejudice. Am I misreading the case law?
No, you are not misreading it.
So what are we doing?
I respectfully disagree with the case law, Judge, and I think what's
I might
problematic.
too, but I'm bound by it.
So, right, and I'm stuck with that. I'm stuck with the fact that defense counsel did not sort of go through the motions of what the case law expects.
I mean, I see why that
counsel.
might be why that mightn't be a good hard and fast rule, right? I mean, who wants to then run out of peremptories later and then you don't know, oh, gee, now I got to say, oh, Judge, I need some more challenges. The judge, I'm not giving you more challenges, and maybe there's or whatever. I get that, but it seems like that's the case law.
It is, and I think this is perhaps this is a federal constitutional issue. I think the problem with the case law as it stands, is that these, jury impanelment isn't that black and white. It's things are fluid, and I think for trial attorneys, you have a better shot generally of prevailing at trial than you do on appeal. And so when you're in the middle of impanelment and you have to make that decision, do I preserve the record or do I worry about who else is coming down the pike in terms of the venari? It can be a tough call. I think in this case, however, this issue of jurors who say, I have to hear from this guy, if he's innocent, he's going to testify. Why wouldn't he? This is problematic. This is critical.
Counselor, are you hoping that will set you up well for FAR or federal habeas? Is that your objective here?
No, I'm hoping you'll agree with me here. But I understand that I'm aware. I'm aware coming into this morning what the case law is, as Judge Rubin said, as Justice Rubin said. So I understand that's problematic for my position.
Can I go back for just a moment to the actual jurors selected? As I understand it, by the time they got to panel voir dire in this case, the jurors challenged had twice affirmed, either by their silence or at sidebar, that they understood the right to remain silent. I understand your position is that was not sufficient given their later response, but had the judge asked them again a clarifying question, would your argument be the same? Assuming that they said, I understand there's a right to remain silent.
No, I think probably my argument would not be the same. I think that what was missing here and what would have probably closed the loop here is had there been some follow-up. And I know attorney conducted voir dire is still fairly new, and there's fairly positive feedback about it. I've been involved in it myself, but I think that the feedback from these jurors in the attorney conducted voir dire, which is where things became problematic for the defendant, I would suggest it needed follow-up, and I think that needed to come from the trial judge.
So your position is without follow-up, it was an abuse of discretion to seat them,
Correct.
even though
Because-
they had twice affirmed their understanding.
Well, they had affirmed when the judge put to them, so I guess the first affirmation would have been when the judge put to them as a whole venari, do you understand this instruction? Can you follow it? Okay, no one raised their hand. They affirmed at sidebar. But I think then what's the point of the attorney conducted voir dire? What's the point of asking this question again? And I think the answer to that is it gets people talking a little bit more and you get a little more feedback from them. And this isn't a question or a premise that, as I said, I'm repeating myself, but this is critical. This is really critical, whether somebody.
And the judge, I don't understand this attorney conducted voir dire. The judge must have some control over what is asked. No? Because the whole thing was phrased in a very odd kind of way. It's more discursive, and you wind up with these kinds of ambiguous, it's like this ambiguous conversation or
Right.
something. It's like, well, is that an answer? Was that even a question? What is going on here?
Right. I think from my own experience, I do this work, but I also am a trial attorney, and I think this works better when it's individual attorney conducted voir dire, because you're right. It becomes like everybody sort of chatting all as one.
And that's not required, right? This could have been
No, it's not.
more structured in some way so that
Yes.
we get clearer. Okay.
Yes, yes. My experience has been that it can be. It's in the discretion of the judge, and these questions that the attorneys intend to ask absolutely can be submitted and vetted by the trial judge. So I guess my concern is, and then if there aren't more questions, I'll leave myself a little time. But my concern is that this particular issue that comes up in my experience all the time, for someone saying, if this person is innocent, if he has nothing to hide, I expect to hear from him. And for these three jurors to say that, and there to be no follow-up whatsoever from the judge. And I think, for example, I will just say, I know in the Commonwealth's brief, they quote Dabney, and that was also sort of a funny impanelment. But I think that actually the trial judge's question there was a better one. She phrased it better, which was, I'm sorry, I apologize. Let me just grab it. If the defendant chooses not to testify, would you hold that against him in any way? Even just one question like that from this trial judge in CRANSHAWN to each of these three jurors, I think would have cleared up whether or not they could be fair and impartial. And I think if there's no further questions, then I'll cede to the Commonwealth.
I see none. Thank you very much. Very interesting case. We'll hear now from you, Attorney Monahan.
Thank you, Your Honor. May it please the court, ADA Megan Monahan on behalf of the Commonwealth. The defendant's conviction here should be affirmed, where the trial judge did not abuse his discretion when he denied the defendant's request to remove three jurors for cause. In deciding whether a juror is impartial, it is sufficient for the judge to determine whether the juror can set aside his or her own opinions, properly weigh the evidence, and follow the judge's instructions. A trial judge's determination that a juror stands indifferent will not be disturbed except where prejudice is manifest. The Commonwealth would suggest that here it was entirely within the judge's discretion to deny defendant's request, where defense counsel's question during the voir dire, essentially, would you expect an innocent person to testify in their defense, did not properly elicit information that could demonstrate the juror's ability to be fair and impartial.
Ms. Monahan, hasn't it been your experience that, generally speaking, when a juror responds to a question and raises an issue like this one, typically there is a follow-up question by the judge or one of the attorneys if permitted.
Well, I would address it in two parts, is that the trial judge certainly could have had follow-up question. Defense counsel did not ask for follow-up questions. And also there was enough on the record for the trial judge to make the determination that these jurors remained impartial, as you, Your Honor, pointed out during panel, during individual voir dire and then the entire venire. The jurors had already affirmed that they could be impartial, that they would weigh the evidence, and that they understood the presumption of innocence. And even
what do we make of the prosecutor's agreement that the challenged jurors should not be seated?
At that point in the first panel where the prosecutor agreed, I would suggest that that was just along with another objection for those jurors, and then the judge made his determination. And it's significant that in the second panel, the prosecutor didn't raise any objections. The judge's determination was entirely within his discretion and was in line with the case law, particularly Commonwealth v. Dabney, which is cited in the Commonwealth's brief, where that question is not, as the quote from the court, that some potential jurors may expect a defendant to testify he or she were innocent, do not without more mean they cannot or will not put aside that expectation and honor the defendant's rights. And Judge Peter Krupp, an experienced Superior Court judge, his findings were directly in line with that case law, and saying that that question did not get to the heart of the matter. And so the prosecutor may have agreed with the objection initially, but this come time for that second panel, this judge reaffirmed his decision there.
Well, would you agree that if the question didn't, in your words, get to the heart of the matter, it at least raised a concern about the jurors' understanding?
I would suggest that it did not, in the sense that, well, as we've discussed, this panel voir dire was very confusing and the questions were sort of all over the place. There was a hypothetical about whether if 12 people stood up and said he was guilty, why wouldn't he testify? And the judge said, well, you know, I don't think the evidence would even show there's 12 people, so that's inapplicable. But even if we were to suggest that the trial judge in best practice should follow up, I was not an abuse of discretion here to look at the record and being in the best position to assess the demeanor and the jurors' responses, that this was within the bounds of the judge's discretion. And even if this court were to find there was an abuse of discretion in that the trial judge should have followed up, then we would be squarely within Commonwealth v. Hines 487 Mass 212, where the SJC found that it was error for the judge not to question a juror further. But there was no prejudice because the defendant did not use a peremptory challenge to remove that juror who allegedly should have been excused, together with the evidence that the defendant was later forced to accept a juror he would have challenged peremptorily. And as counsel has suggested today, the law appears to be that they did not exhaust their peremptories. Defense counsel did not use the challenges on these three jurors, suggesting here that defense counsel was satisfied with their impartiality and would want them.
Do you think that's a hard and fast rule?
I think the case law would say that it is, in that, and where we are with Commonwealth v. Nelson, 91 Mass Appeal Court 645, Commonwealth v. Bryant, 447 Mass 494, all cases that would be in line with what occurred here. And I think what is also, in preparing for this oral argument, what I found in the record, which was interesting, was that initially the panel was going to be 13 jurors. And then the judge noted that they had 14 available jurors ready to be seated and would only accept 14 if counsel of both parties agreed to that. And defense counsel said, if we have 14 jurors, then we should seat 14. And that suggests here again that the defendant could have, that next juror could have said, no, without any challenge, we're not going to want that, but he accepted that juror as well. So I would suggest that the defendant can't show prejudice and that it would not be reversible error here.
Ms. Monahan, can I go back to something you alluded to earlier regarding best practice?
Mhm.
Is it the Commonwealth's position that it would have been the best practice for the judge to follow up with clarifying questions?
I think that the Commonwealth's position here is that there was enough on the record that the trial judge, it was entirely within his discretion to say that this question didn't raise a concern about prejudice. There's no evidence here that there is prejudice. And based on the record, these jurors have already affirmed twice.
Well, that is a response, but it wasn't really responsive. Is it your position that it would have been a better practice to ask the clarifying questions?
Yes, it would have made this record much easier and much simpler and better practice to just ask. But again, defense counsel didn't request further follow-up or questions. And I think it's Superior Court Rule 6, where it's entirely within the judge's discretion to not ask further questions if counsel hasn't properly laid a foundation. And so counsel here didn't lay that foundation.
Counsel, that may be so, but ADA Burr is a pretty experienced attorney. You might want to suggest to him that next time it would be sensible to suggest the judge follow up.
Yes,
And
Your
Attorney
Honor.
O'Brien will have some suggestions for the defense counsel on their peremptory strategy.
Yes, I think for appellate record, it would be preferable for follow-up questions if there's any concerns whatsoever, but this is what we have here. And I think just a last point I wanted to make was we were discussing the submitting questions and whether the judge had the discretion there. And so in the record, it's not in the record appendix, but looking at the docket, there was motions in limine requesting the panel voir dire and submitted questions, and reviewing those filings. Defendant did not have these exact questions there. So it was something that just came up there in the panel voir dire, which I think does happen during the course of these panel voir dires, that it's a reaction to answers. But if there's no further questions, the Commonwealth would rest on its brief.
I see none. Thank you very much. Excellent arguments.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Judge Rubin, and I'm joined today by my colleagues, Judge Kinder and Judge Ditkoff. The next case we will hear is number 21-536, ROSA versus Affordable Interior Systems, Inc. The rules for argument are the same when we hear argument by teleconference as we are today due to the ongoing pandemic as they are in our courtroom, which is to say 15 minutes per side and no rebuttal. And we will hear first from Attorney Leahy.
Thank you, judges. May it please the court, my name is George Leahy. I represent the appellant Alexander Santiago Rosa. This case arises from an April 7th, 2020 dispositive motion down in the Superior Court, where the trial judge at that time had allowed the defendant's motion to dismiss under 12b-6. The focus of the motion to dismiss was under Molina versus a State Garden case, where the alternative employer can escape a tort liability in certain circumstances. The alternative employer in this case is Affordable Interior Systems, Inc., which is the defendant. The temporary employer was Randstad North America, which was the temp agency that had employed Mr. Rosa and placed him for employment over at Affordable Interior Systems. The plaintiff's complaint, which was filed on March 6, 2020, had 3 counts. First was for negligence, second was for gross negligence, and count 3 was for recklessness, willful, and wanton conduct. The defendant did not answer the complaint, but immediately filed what they classified as a motion to dismiss or motion for summary judgment. Now, the facts of the case are as follows. Mr. Rosa has a very limited educational background and skill set. He does not.
Mr. Leahy, can I stop you regarding the facts? We've read the factual background carefully. Let me move on to a question about the documents.
Sure.
I understand that there is a disagreement about whether or not the judge should have considered the documents attached to the motion to dismiss and what they mean. But I'm curious as to whether or not there's disagreement about the content or the authenticity of those documents.
Well, Judge, very good question. And that's one of the major focuses that was brought up down below to the Superior Court. If you have, for example, under Molina State Garden, you need two things. You need a waiver and you need a special employer covered by the general employer's workers' compensation policy. You need both. If you have one without the other, it doesn't work. And Affordable Interior Systems does not get to preclude itself from tort damages. In this particular case, let's just take a look at the waiver. The waiver is signed by Mr. Rosa. I, at the time, because of COVID, had not had the usual circumstances where I meet one-on-one with the person. It came in through me through a referring attorney. This was produced in pretrial discovery among letters that go back and forth in the notices. It was written in English. It was not written in Spanish. He does not read or write English associated on that or understand it. There also was no payment for.
I'm sorry, I don't think that's responsive to Judge Kinder's question. I think he's asking if there's a dispute about whether this is the authentic. That's a legal question, whether something in English is good enough or not, right?
Okay.
I think he's asking, is there a dispute that these are the relevant documents?
Yeah, let me narrow it just a little bit more. I'm really focused on three documents: the waiver, which you've already mentioned, the staffing services agreement, and then those endorsements to the insurance policy. And my question is, do you agree that those are the documents that govern this case?
Absolutely, Judge. The problem that I've got with that, though, is anytime I deal with an insurance policy, you have to have the complete policy with an affidavit indicating from someone that it is, along with all the endorsements. The analogy that I can give the court is, let's say I have a triple net lease with Costco that's involved and someone's disputing liability associated with that. Defense counsel produces 10 pages of the 100-page lease. I don't know what is in the other 90 pages. In this particular case, defense counsel provides cherry-picked, I think, three separate endorsements associated with that. One of them was the informational page. The other was the alternative employer's endorsement. And the third was the mandatory endorsement, an employer's endorsement, as well as the contract that they had between Randstad and also Affordable Interior Systems.
Well, I'm just thinking out loud here, but that may be because those are the documents that Molina says control.
Perhaps, but what happens in any policy is some endorsements add, some take away. And unless you have the entire policy that's in front of you, in fact, when I had opposed the summary judgment motion, I indicated that defense counsel had not even provided the body of the workers' compensation policy. He then went on to what's called the Insurance Services Office, which copyrights various policies. And I believe he printed out a form and applied and provided that to the court in a reply brief. I'm sure that they followed an ISO policy under the circumstances, but we don't know if there are other endorsements that would add or subtract.
I'm a little surprised. I hear what you're saying about the full policy. And I guess my inclination would be to agree that without seeing the full policy, how can one know exactly what's referred to what and what exempts what and what's excluded and what's included? I'm a little surprised to hear you say that you agree that this is the agreement between AIS and Randstad when there's no affidavit saying that it is. How do you know what it is?
I don't, Judge, and that's certainly not on motion to dismiss, and I'd agree with you, but for the purposes of the appeal, I deal with defense counsel a lot. I can't imagine under Rule 11 that he would submit to the court documents that are false or fictitious associated with that. And
That's
so
fair enough.
I'm giving him the benefit of the doubt on that for the argument that we have here. Notwithstanding, if I drop back into the argument that you've got on each one of them, let's take what I think is perhaps the easier issue associated with it is, if you look at the actual policy and the language that's in it, they don't dot the I's, they don't cross the T's. All right, they don't have it. Bluntly, this is not my first rodeo in dealing with these cases before. You have to be very specific in that policy. They were not. There are gaps in it. They don't reference the contracts that are in there. They don't reference this particular Affordable Interior Systems, Inc. And candidly, what happens is there's always a shifting when you deal with these types of cases, because as was referenced in the Horner versus Boston Edison case, which defense counsel had brought up, that upheld the lease against somebody who was for a company that was employed over at Boston Edison. He missed a step, fell down, and became injured. He had a union to protect him associated with that, but the court upheld the release, said that the consideration for the waiver was his continued employment. The problem that you've got is, in that case, is you never had a lack of comprehension of it, and there was no gap in the employment. Here, if you recall from the facts, Mr. Rosa worked for them starting, I believe, in July. Then he stopped in late October, then started up again in November. When they restarted up again, they never had him sign a new waiver. They never had him sign up a new employment application. He has no idea when he works for a temp agency who he's going to get assigned to. But in the shifting that you've got with Horner, that the court indicated they weren't going to address, is under Mass General Law, Chapter 152, Section 15, the recovery of the tort damages are always first for the compensation carrier. And they have to bear a proportionate share of the attorney's fees and expenses. Any residual or excess goes back to the employee. So there is a shifting of the policy monies. But even more than that, and this is not in the brief, it's my knowledge from doing this, anytime there's an industrial accident, there are experienced mods. These mods increase the cost of the premium to the named insured in a workers' compensation policy. Makes sense. If I have an unsafe factory, I want it so that the compensation costs become very high, so that they in turn will try and make a safer factory, like in this case, put the guard on that really should have been there, and therefore reduce the workers' compensation premium. But on a retroactive policy, what happens is the insurance company or the named insured, if they recover from the third party, reduces the increase in the premiums caused by the experience mods to the named insureds. Therefore, they get a windfall within the retroactive period, usually 3 to 5 years, on a workers' compensation policy. So what
Mr. Leahy, can I interrupt with a kind of a big picture question?
Sure.
At the hearing on the motion to dismiss, you, as I recall, told the Superior Court judge that your client was continuing at that point to receive workers' compensation payments. Does that remain the case today?
I believe so, Judge. I know there was some talk between the attorney who's handling the workers' compensation, Karen Seward. I do not handle the workers' compensation. I'm brought in candidly just to try these cases on the toward end of the factor. My understanding was that he was still receiving workers' compensation benefits. I don't believe that there was a lump sum settlement yet under the workers' compensation statute.
And if you were to prevail on this appeal and then prevail in the Superior Court, whatever damages were awarded would be subject to a workers' comp lien. Is that correct?
Absolutely. Under Section 15 of Chapter 152, I even have to have approval of either the Superior Court or the Industrial Accident Board of the settlement. And they go through, my fee agreement to make sure it's reasonable. They go through each and every expense. If I don't have a check with a matching invoice, you don't get the third-party case approved. So,
Counselor, what should we do if we decide that if this were a summary judgment motion, and these were the documents in front of us, summary judgment would properly be entered against your client, but that it shouldn't have been considered on a motion to dismiss? What do we do in that situation?
the judge specifically, when I raised this issue, said he was not going to decide it on summary judgment. All right. When you look at every case that's here and even the ones that were provided, you take a look at any one that's come up. Every single one of these cases has been decided by either Superior Court or the Appeals Court when they look at it on a summary judgment. Never, and I don't believe there's one that was decided on a motion to dismiss.
So is your answer we should reverse in that circumstance?
I think that under the circumstances, you have two options, if I can be so bold. One is to say, Judge, you didn't have sufficient documentation under 12b-6. Therefore, this would be more appropriate for a summary judgment after underlying discovery had prevailed associated with it. For example, there was no affidavit, there was no complete workers' compensation policy, there was no vetting of the waiver that was provided, nor substantiation of the gap on whether or not they should redo that. If that's the case gets remanded to the Superior Court and the case proceeds forward with the discovery. Counsel can then, and I'm sure that he would, press forward with a summary judgment motion at a later time. The other one is to say, let's not save some time, money, and effort that's involved for everybody. I know that ultimately, if you court remands this, which I believe that they definitely should, for resurrection of the plaintiff's tort action, that it's going to come up again on a summary judgment motion. And if you look at the exact same things that are in front of this court, the waiver and these special employers workers' compensation policy endorsements, we don't have it. Why waste the time and the effort to go through that and to say basically the waiver is inappropriate? Two, if you take a look at it, 100%, the policy just doesn't dot all the I's and cross the T's under these.
Can I ask you a question about the waiver? Do you have a case that suggests that a Spanish speaker signing an English language waiver, that the waiver is ineffective?
Counsel and the defense brought up case law, which basically says if you sign it, you're stuck with it. All right. The issue that I've got is I am very troubled by that. You're having somebody who is waiving their tort rights. Workers' comp only pays 60% of your lost wages and 100% of your medical bills that are causally related. You get nothing for pain and suffering. Scarring is.
No, I understand that, but I'm asking if there's any case law that suggests that a non-English speaker signing an English language contract isn't bound by it.
None that is in my brief or that I am aware of, Judge. All right. That was not my focus associated with this. A lot of it had to do with, let's say, consideration that we're on this. It's call it, if you have a non-comp agreement now and the company is bought out, you have to sign a new non-comp. And under the new case, the statute that came down, you have to have separate consideration for a non-comp. So what you've got is, from a social policy perspective, usually I see non-comps in white collar employers, all right? And they're getting compensation for signing a non-competition waiver. Yet you get somebody like Mr. Rosa who just wants a job, all right? And he's going to a temp agency. Well, he is overreached associated with this. He can't do anything. And ultimately, if you look at the big picture, as prior justice had brought out, it's a shifting between insurance companies. Who is the CGL, or comprehensive general liability carrier, going to pay it? Or is the workers' compensation carrier going to pay it? And the one who has no negotiating leverage associated with that is someone like Mr. Rosa. He has nothing, to come in. He's just happy to get a job. And that to me is, I think it's unconscionable. And that's not the purpose of the court. My time has expired, I believe.
It has. If there are any other questions, though, no. All right. Thank you very much. Very interesting argument. We will hear now from you, Attorney Sheehan.
Good morning. May it please the court. Jennifer Sheehan for Appellee Affordable Interior Systems. So I want to just touch on a couple things. First of all, the Molina case, this facts of this case are almost identical to the Molina case. And I do want to correct that the test for whether the alternate employer gets is immune from suit was misstated by my brother. It's not, there's no requirement of a waiver. In this case, as in Molina, there happens to be a waiver. That's a separate thing, and I will talk about that in a second. But in this case, there's a two-prong test, which is—
Can I stop you before you go too far? You suggested that this was on all fours with Molina. But wasn't the temporary employer in Molina a named insured in the policy?
Was, but I do not think that that was a dispositive question in reading the policy. The named insured, the alternate employer in Molina did happen to be specifically named on the policy, but it's very common in insurance policies for additional insureds to not be named, but still be added by endorsement, and some, characterized as blanket endorsement, where it might encompass all companies that the named insured had a contract with. And if the requirements for additional insured coverage are met, that other party is entitled to the same coverage as the named insured on the whole, without having been specifically named in the policy. So the fact that they were not named in the policy I don't think it distinguishes it in a meaningful way from Molina.
I know that the Superior Court judge cited one case where that was in fact the holding, but are you aware of any, that was a Superior Court decision, are you aware of any appellate court holdings that so held?
Not in this particular context, but I know that there are many cases where they have found additional insured coverage by means of an endorsement which did not directly name the party seeking the coverage. And I would be happy to provide those. I don't think there's any in my brief, because that's a separate issue than what we were focused on, but I would be more than happy to provide cases in that vein. So just to go back, so the test for immunity, it's a two-pronged test. It's set forth in Molina, it's set forth in Lang and other cases. It's that the employer seeking immunity is an insured person liable for payment of workers' compensation benefits to the injured employee, and that they are the direct employer of the injured employee. And in this case, AIS meets both of those qualifications. The first one, it meets by virtue of the a mandatory endorsement to the Randstad policy. And the second, it meets based on, and that particular prong can be met by just reviewing the complaint. They were the direct employer. They supervised the day-to-day work of Mr. Rosa. And so they've met both of those prongs for immunity.
Can I ask you a question about the mandatory endorsement, which I'm looking at in another screen here?
Yep.
The second clause in that sentence says, except that no client is an alternate employer for claims arising out of the alternate employer's negligence, unless that applicable contract specifically denotes such an obligation. Can you point us to the place in the contract where it is that specific denotation is?
Yes. Sorry, bear with me. It's actually at the top. God, where's the? It's on the first page of the staffing agreement, and it says that the it's, I think. Sorry, I don't have my paper here. It's paragraph, I believe it's G, that it says that the Randstad will be solely responsible for all unemployment and workers' compensation claims. And so if we're going back to principles of contract interpretation, where we talk about the word all would necessarily encompass negligence claims, which are probably the most common type of workers' compensation matters, as well as gross negligence or recklessness.
I'm sorry, what page of the appendix are we looking at here? Do you have it in front of you?
It's 43.
Sorry, yeah.
I think you're actually in 42, paragraph C.
Okay.
I apologize. I had it. I had it a second ago.
Is what you seem to be reading from. You said
Yes.
G would be on 43, but I think you're reading from C, which is on 42.
Yeah, it's the reference to the word. It's the use of the word all in describing the type of claims, both all workers' compensation and all unemployment claims and workers' compensation claims. So it's
Well,
our
but that's
position.
not about the alternate employer endorsement. They have handled the workers' compensation claim.
Right, but I understood the question to be referring back to the language in the mandatory endorsement, which is supposed to complete the schedule in the alternate employer endorsement, and that has the language that says it first of all describes an alternate employer as all clients for which the insured has agreed to provide workers' compensation and employer's liability insurance under a written contract or agreement, except that no client is an alternate employer for claims arising out of the alternate employer's negligence unless that applicable contract specifically denotes such an obligation. So in this case, the applicable contract, which required Randstad to have this kind of coverage for AIS, is the staffing agreement. And the staffing agreement specifically says that Randstad will be solely responsible for all unemployment and workers' compensation claims. And so it's our position that the word all, just going by its plain language, does not exclude anything, and it includes negligence.
No, I'm sorry. I don't understand this. So the such an obligation, no client is an alternate employer for claims arising out of the negligence unless that applicable contract denotes an obligation. You say that's an obligation to provide workers' comp, or is it an obligation to make them an alternate employer for such claims?
No, I'm saying that it's an obligation to cover all claims, so that this exclusionary—
I'm sorry, to cover meaning to pay workers' compensation for. Because that's, C says the all is solely responsible for all unemployment and workers' compensation claims.
Right.
And I'm just trying to figure out what the phrase such an obligation refers to.
I think such an obligation refers to the coverage of claims arising out of the alternate employer's negligence in the mandatory endorsement.
Okay, so. You don't think so? Okay, I guess I'm just confused about the language here. Such an obligation, no client is an alternate employer for claims arising out of its own negligence, unless the contract specifically denotes such an obligation. An obligation to what? To make them an alternate employer or to pay workers' compensation?
Your Honor, I absolutely agree that this language is not the model of clarity, but I think it should be read to say that there's two phrases here. So who constitutes an alternate employer? That's a client for which the insured has agreed to provide workers' compensation under a written contract. So that's the first prong of the second, then of the statement. Then there's an exclusion to that category, which is no client could be construed as an alternate employer for claims arising out of their own negligence. But then there's an exception to that exclusion, which is unless the written contract denotes such an obligation.
An obligation to make them an alternate employer for claims arising out of their own negligence.
Exactly. And so it's our position that the staffing agreements reference to all claims is enough to encompass, going on the parties' understandings. If you're reading that, you would assume that it would include negligence claims under all claims. I also just wanted, but to address that, even if this court were to find that this mandatory endorsement, that AIS was not an alternate employer for the purposes of Mr. Rosa's negligence claim, now we get into the release. And with regard to the release, absolutely Massachusetts law favors the enforcement of releases. There's and as you pointed out, there's no cases that say the fact that you didn't read a release or the fact that you didn't understand it would bar its enforcement unless there were allegations of fraud or duress. And no allegations have been made that there was any kind of fraud or duress. Some of the requirements that
well, if Randstad, and I don't know if this is the case, Randstad knew the plaintiff couldn't read the waiver, and ask them to sign it, isn't that fraud in itself? To ask someone to sign something that they they can't read and understand unless you explain it to them?
I mean, possibly, but that was never alleged, and we also don't know the circumstances of that, and that's never been raised, even in Rosa's opposition to the motion to dismiss. He did not claim that there was fraud or duress. It was simply that his client couldn't read or.
Isn't that something for discovery, depositions?
I mean, but it wasn't alleged in the complaint. I think we need to go back to the complaint, and that this was properly. I also just yes, I think we need to go back to the complaint. There was no allegation at the complaint stage or at the opposition to the motion to dismiss stage that brought up any allegations of fraud or duress.
I mean, also not in the complaint is any of these documents you're
I
relying
would-
on. How can you consider them in a motion to dismiss?
I would address that in two ways. First of all, I think that there are allegations in the complaint which do, if you're viewing all the allegations as true and the inferences that may be drawn from them, he talks about Rosa being assigned to AIS by Randstad. I think that implies the existence of an agreement. He talks about workers' compensation coverage. I think that implies the existence of the workers' compensation policy. I also want to address that the fact that this was heard on as a motion to dismiss, and a lot of similar cases were heard at in the summary judgment context. We don't know the background in those cases about how the documents were presented. But in this case, Attorney Leahy had possession of the staffing agreement. In fact, he provided it to predecessor counsel before my firm came on the case. He provided the staffing agreement in some correspondence that he had with the other attorney. He was aware of the release also, and in a letter prior to filing suit that our firm wrote to him in response to that, we set forth all of these arguments about the applicability of.
But you've never produced to them the whole workers' comp policy?
We produced, it was my understanding, I thought that the entire policy was produced as part of our reply brief. But I don't know if that included all. And
can I ask you a question? He also says that this waiver may be only applied to an earlier period of employment, and then there's a gap, and then re-employment. How do we figure that out? Is that a legal? I just don't know.
I would say, Your Honor, in support of that argument, first of all, again, the gap in the employment is not mentioned at all in the complaint. He talks about Rosa having worked at AIS.
Okay, but you produced this document and we're supposed to be relying on it. I mean, this is maybe part of the problem doing this on a motion to dismiss. Okay, yeah, well, so here's this way, but there's a waiver, but how are we supposed to know if it applied? Maybe it's expired. I don't know anything. I don't know how we're supposed to sort that out.
Well, I would say that the appellant has not produced any cases that require a re-signing of a waiver of a gap. He's talking about the non-competition.
Wait.
Yes.
You don't think that if I work for someone and I waive certain rights and then I go get another job and I come back, you think it springs back into life for all eternity? That can't be.
No, but in this case, I mean, there was a small gap according to the later documents. I don't think that there was enough of a gap, and at the time of of his employment, he'd been working at the same place for 7 months. And the gap is, he talks about the gap in the context of non-compete contracts, which are not. They have a different purpose, a different motivation, a different policy rationale than this kind of waiver.
How did he rely on the waiver in framing his complaint?
He did not mention the waiver. There was a single allegation that said Mr. Rosa does not read, write, or speak English, which I presume was a.
And how did he rely on these amendatories to the workers' comp in framing his complaint?
He alluded to the existence of the workers' comp policy, but I would argue that he had knowledge of them because they were talked about in prior correspondence with predecessor counsel and with our firm before the the complaint was filed, and that he was well aware of them.
He might have had knowledge, but to be considered without conversion, he has to have relied on it in framing the complaint. And you're saying he didn't, or he alluded to them, I guess?
I think the existence of the staffing agreement, which does include the waiver and which does include the language about the mandatory endorsement, he absolutely relied on that because he, again, the fact that he didn't mention it, I don't think that there's case law supporting the fact that a plaintiff can selectively choose which items that he has knowledge of to include in his complaint because they don't fit with his framework of the argument. But absolutely the staffing agreement is implied in there, putting aside his possession of it, it is implied in there by his discussion of the interactions between his assignment to AIS, the interactions between the two organizations in terms of supervisory duties and that kind of thing that are all in the complaint.
Okay, your time has expired, but it's a complicated case. So if there are other questions, I don't want to. No, I see none. Thank you both. Excellent arguments, both of you. It is a complicated.
The case is now being recorded.
Good morning. Welcome to the Appeals Court, where we will continue with number 21-393 Tochi Building Corporation versus, I'm going to call it IRIV Partners, although I have a sneaking suspicion it's IR4, but you'll let me know. I am Justice Rubin. I'm joined today by Justices Kinder and Ditkoff. The rules for oral argument when we hear argument by video conference, as we are today due to the ongoing pandemic, are the same as for argument in our courtroom, which is to say 15 minutes per side with no rebuttal. And we will hear first from you, Attorney Smirridge.
Thank you, Justice Rubin. Good morning, members of the panel. May it please the court, Roger Smirridge on behalf of Tochi Building Corporation, the appellant in this appeal from the single justice. Tochi's appeal presents a single question. Does this court apply the plain and unambiguous language of the rules of appellate procedure concerning the timing for taking appeals as written? And I submit that the answer to the question is yes, and that the result here is that the owner's untimely appeal must be dismissed. The single justice here did not apply the plain language of rules 4A and 14B, and her orders granting the owner's motion for untimely appeal and denying Tochi's motion for reconsideration should be reversed for two reasons. First, the plain language of those rules unambiguously provides that the owner's first notices of appeal were of no effect, and that their second notices of appeal were too late. Both this court and the SJC have held that those rules, and specifically Rule 4A3, mean what they say, that a premature notice of appeal is of no effect and a new notice must be filed. Second, the record also reflects that the owner's counsel here waited over 2 months to file the new notices of appeal after their post-judgment motions were decided, with no showing of excusable neglect or good cause for that delay. As such, allowance of the untimely appeal here was both an error of law and an abuse of discretion. The starting point for this appeal is the text of Rule 4A. Rule 4A2 provides that certain post-judgment motions toll the appeals clock. One of the motions covered is a motion to alter or amend the judgment under Rule 59, however titled, so long as the motion is served within 10 days after entry of judgment. Rule 4A3 then goes on to provide that a notice of appeal filed before disposition of any timely filed motion listed in 4A2 shall have no effect, and a new notice of appeal must be filed within the prescribed.
I'm afraid I have a metaphysical question for you.
Go ahead.
I think this comes down to metaphysics, maybe. I see everything you're saying. I'll ask Attorney Donahue, but it looks to me like the reason they didn't file a timely notice of appeal was a misunderstanding of the effect of their filing of the motion for reconsideration. Maybe they were misled, or I don't know, by the fact that the lower court, despite that filing, continued to treat the notice of appeal in some way. And maybe that's excusable neglect or not. I'm guessing it happens in every case, so I don't know. Let's say it's not. The single justice cited, maybe I don't remember if it was a C also cite or a C cite, Roche v. Malika. Roche v. Malika allows an appeal to go forward without a new notice of appeal when there was a filed but nullified notice of appeal. If that's okay, how can this not be okay?
So, Your Honor, what I would say regarding Roque is that the footnote in question, which did allow an untimely appeal, and I note that the SJC in that—
Not just untimely, they never filed another notice of appeal. They let it go forward with the nullified, a notice of appeal that the rule says is a nullity. The plain language of the rule was heard by the SJC.
I would suggest that it actually wasn't heard by the SJC in that case. The issue of the timeliness of the appeal was not presented in a Rule 4C or 14B motion. The issue was not briefed. It was not argued.
Jurisdictional, or I would have thought it was jurisdictional.
If it was jurisdictional, then I would suggest that the SJC's analysis needed to be more robust than a footnote.
Well, someone should tell them.
Well, I would certainly invite this panel to do so and present the issue for them. But I would actually suggest that they've already gone ahead and revisited the issue, although without citing Roque. In 2020, in the SJC's decision, U-Call LLC versus Entwistle, a case that actually involved the timeliness of an appeal, whereas Roque did not. The holding in Roque only addressed the personal jurisdiction question, which the SJC panelists were obviously very interested in Roque. It's a compelling argument, actually, if you go back and watch it. But in U-Call, the SJC, after Roque, expressly recognizes that Rule 4A3 renders premature notice of appeal ineffective. And it contrasts that with the rules governing premature post-judgment motions. And the SJC in U-Call recognized that post-judgment motions that are premature can still be valid, whereas notices of appeal, which are premature in that they're filed when a post-judgment motion is pending, cannot be valid. If Roque had the meaning that the single justice ascribed to it here, you would expect the SJC to have said so in U-Call, or more appropriately, to have engaged in the rulemaking process.
Newhall is after or before the single justice order in this case?
Before. U-Call is a 2020 decision.
And let me ask you this. Why isn't receipt of something from the trial court indicating that they're going ahead and putting the appeal together, notwithstanding the filing of the motion? Why mightn't that support a finding of good cause for excusable neglect?
Why might it? I would suggest it wouldn't.
Why?
The notice of appeal filed form is a form that the Superior Court issues whenever a notice of appeal is filed. It does not purport to reflect that the notice was timed.
No, but I understand that it's not, obviously it doesn't actually trump the language, but the question is whether it might lure someone into mistakenly thinking that their prior filed notice was still good, right? That would be the excusable piece.
No, I don't believe so, Your Honor. Under this court's cases, including Pierce versus Hansen Engineering, Shav versus Alvord, BJ's Wholesale Club, all those cases, and even Troy Industries, the case that my brother relies on, they all stand for the proposition that misunderstanding or confusion by an attorney of the effect of a rule is not excusable neglect. Whether that—
I'm talking about the effect of the rule. I'm talking about whether when the court sends you something I mean, maybe, and I don't know anything about this, maybe the attorneys for your opponents are seasoned appellate advocates constantly doing this. But I think to myself, somewhere there's a sole practitioner who isn't very good at this and never did it before, and it's their first appeal. And it's true, the rule says that this thing nullifies this other thing, but then they get a notice saying, oh, we're putting the appeal together. And then later there's a motion to dismiss or, saying there's no valid notice of appeal. And they come in and say, oh, I guess we're late, but our excuse is we got this thing from the trial court and it misled us more than the rule did. And so, we know we were wrong. It was neglect, but we're saying it was excusable.
And I would say that yes, there's a case, I can't recall if it's Troy Industries or one of Attorney Donahue other cases where the counsel called the clerk and the clerk said that no, the appeals clock hasn't started. In that instance, perhaps, but that's not what the notice of appeal file form from the Superior Court here says. So for that reason, I would suggest on this record, there is no excusable neglect. And I would also suggest that the prudent advocate, when receiving a form like the notice of appeal form here, should go back to the rules. Our courts do impose a duty on attorneys in the Commonwealth to review the rules and be knowledgeable about them. As to the trap for the unwary, you raised a good point, Justice Rubin, because the federal system has actually addressed this issue. In 1993, the federal court rules were amended to change the language of the rule. The federal rules prior to 1993 had the same version of the rule that we have in Massachusetts now. In 1993, the Federal Rules Committee changes Rule 4A to provide for springing notices of appeal. So if a prospective appellant files a notice of appeal while a post-judgment motion is pending, whether it's theirs, whether it's the other side's, doesn't matter. Once the last post-judgment motion has been decided, then the earlier filed notice of appeal springs into effect. And the Federal Rules Committee said this helps clarify a confusing situation. But our courts, our SJC, in more than 30 years, or almost approaching 30 years next year, has not seen fit to amend our version of Rule 4A. And the footnote in Roque certainly, I would submit, cannot substitute for that rulemaking process.
But what are we supposed to do? You have to file an SJC case, even if it's wrong. And it says that the concerns underlying Rule 4A are not implicated where no action on the appeal has yet been taken before the motion for reconsideration was decided, which is the case here, I think.
I would disagree that those concerns weren't what the SJC did, or that the citation that the SJC offered supports it. The SJC's lone citation was to Anthony versus Anthony, a case in which this court said that Rule 4A3 is to be given unqualified effect going forward. So doing what the—
But then they didn't give it effect.
I'm sorry, Your Honor?
But then they didn't give it effect.
Because that
appeal.
Well, that appeal had been— are you talking about the SJC in Roque or this court?
In Roque, yeah.
And again, I would suggest that they did so without analyzing the issue. And
I fully agree with you. It seems a complete violation of the plain language of the binding rule.
And I think if the court were looking for a way to distinguish or not have to be felt confined by Roque, U-Haul provides that that opportunity.
I don't get that. All that happens in U-Haul is they say that in a summary process situation, a motion to reconsider tolls and restarts the clock. They don't say that a notice of appeal filed before such a motion is ineffective. So how can I take U-Haul as overturning sub silencio Roque?
So if you look at, it's on page 1021 of U-Haul, It's the paragraph that goes from 1020 to 1021, starts Rule 59 requires, and at the end of that paragraph, when the court is discussing the two situations and whether what premature filings are effective and not effective, the SJC says contrast Mass Rule App Procedure 4A, notice of appeal filed before disposition of enumerated timely filed motions without effect. If the
I see. I didn't see that before. I see now.
Yeah, and if the SJC had meant Roque to have this broad effect, then this statement in UCall would not be there. Instead, they would be saying, see last year's decision in Roque, in which we basically said, Rule 4A3 isn't going to have the meaning that its plain language describes.
Yeah, but the whole, I mean, well, you see our problem. I mean, for there to be a rule of law, we have to ought to follow exactly what they did. And I'm not sure why your opponent should be treated any worse than the appellant in Roque. And if the SJC wants to explain that they didn't mean to got 4A3, then they can tell us about that.
Well, and I would say that even here, let's just, even with the Roque issue to the side, you still have to make a showing of excusable neglect for a 14B motion.
Yeah, but how can we treat them worse than someone who didn't even bring one in Roque? They didn't even bring one. They had a nullity and the court heard the case. I mean, I don't know what to make of Roque, except it seems wrong, but that's not.
I've struggled over the past few days what to make of Roque myself, Your Honor, and it really took a good parsing of UCall, as Justice Ditkoff just suggested, to figure out what exactly is going on in that case and how does the SJC itself square its footnote in Roque with the plain language of the rule. And perhaps in UCall, they should have said, you know what, in Roque, we made a mistake. That's not actually the rule. They didn't, but they did reiterate what Rule 4A says in its plain language. And again, I think that is the key here. And the single justice didn't grapple with that plain language at all, just had the see also citation. If there was some other support, maybe that would be fine for the single justice's order to stand up, but there is none.
Okay, your time has expired. I think we understand the argument. We will hear now from you, Attorney Donahue.
Thank you, Your Honor. May it please the court, Michael Donahue for what is, you correctly intuit, IR4, although we call it IRIV in the nomenclature of this case because it's just easier, I think, and Boston Harbor Industrial Development, BHID. I want to start back at the beginning where Mr. Smiraj started. This court has 2 points of inquiry this morning, at least as far as this appeal is concerned. One is whether the single justice applied the appropriate legal standard, which she manifestly did in finding that there was good cause to extend the time period for filing a notice of appeal.
Manifestly? You're reading a lot.
Her order says, I apologize, Your Honor, I didn't mean to interrupt you.
No, manifestly, you're reading a lot into one sentence.
It says for good cause shown, I believe, Your Honor, right?
No, it just says allowed, the notices of appeal filed on 4/21/21 are deemed timely filed. See also Roque versus Malika.
Even so, I apologize if I'm misremembering that, Your Honor, but even so, I don't think you can conclude that she didn't apply the right standard. And then that really makes this a matter of whether the single justice abused discretion.
All right, what's your good cause?
Good cause? Well, good cause, there are two grounds for good cause. One is that when I did not receive actual notice of the entry of the denial of the motions for reconsiderations, which would have triggered the running of the appeal period. And the reason for that, Your Honor, is a combination of disruptions in office procedures caused by the COVID pandemic and the fact that my father had unfortunately passed away a few days prior, which meant that I was on bereavement. And this is
No,
all,
of course, those are serious matters, and those would be good cause, I would think, for a delay in filing something. But once you became aware of the order, nothing was filed for like a month, maybe more, I don't remember. So isn't the question whether there was, and then I thought when you finally did, I guess there was some motion practice based on the absence of a valid notice of appeal that must have triggered action in our court. And then you filed something saying, oh, all right, well, here's the notice of appeal. I gather that your point was that really what this is about is we misunderstood the rule and we received this thing from the trial court saying whatever the record was being assembled or whatever that notice says.
well, in that instance, that's correct, Your Honor. I think our argument is more that it's a confluence of circumstances. And I certainly recognize that there was an initial failure and then a subsequent delay caused by a misapprehension of what the trial.
Okay, but that's the only one that matters. If you had filed this the day you became aware of it and said, listen, oh my gosh, we have no valid notice of appeal, and because of COVID and bereavement, we didn't, we messed this up, I don't think we'd be having this appeal probably. But that's not what happened. What happened is, as I understand it, I thought your position was you were not aware that you needed to file a new notice of appeal, even once you became aware of the denial of the motions, right?
I mean, that is in fact a factor, Your Honor, but in my view, it is a factor that takes us out of Rule 4C and puts us into Rule 14B. I mean, had we moved more quickly under 4C, we would have been in the trial court. It's the same standard, I would argue. So I think the secondary lapse and the secondary lapse caused by misapprehension of the rule based on the order that we received from the trial court is really a function of an additional time lag, but honestly, it's not a function of the deadline passing in the first instance, and that was caused by the factors attendant to COVID and office procedure and my father's passing.
I don't understand that. I don't. Then when you became aware of it, why didn't you, if you knew that, if you were waiting for the notice and then you got the notice, and so you had whatever it is, 30 days to file a new notice of appeal, why didn't you file a new notice of appeal within 30 days of receiving actual notice?
That piece, Your Honor, is in fact related to the misperception.
So isn't that what we need to look at for whether that creates excusable neglect?
Well,
right, we can only get to 30 days after actual notice from the other, right?
I mean, I think you do have to look at it, Your Honor, and I think that there is support in the law, certainly in the Karen Construction and Troy Industries cases, which recognizes that kind of a misperception and that kind of a reliance on the clerk's offices in those cases is not in and of itself usually enough, but it can present grounds. And in this instance, the single justice has extremely broad discretion to make a determination of whether grounds exist to extend the time for filing. And what that means is that abuse of discretion is that the single justice taking a view or action that no conscientious judge acting intelligently could honestly have taken. That's the language of Troy Industries.
Do we have a copy of the notice that that you received that you say was misleading?
I believe it is in the record appendix, Your Honor.
Okay, I'll find it. I don't want you to have to take your time.
It is in fact there, and Mr. Sparrish is not incorrect. It's a standard notice that goes out, but it is a notice from the court that said, we're assembling the record, tell us if you want a transcript, that kind of thing. And again, it's a matter of honest misperception, I think, which explains the failure to immediately act. And quite honestly, nothing happened for a period of time, as you pointed out, and then Tochi tried to obtain an execution, and that's what understandably made us look to see if that was proper. And then there was some motion practice around the execution and motion practice with the single justice under Rule 14B.
Do you think Roque has anything to do with this?
I do, Your Honor. I absolutely do. I think that that's a case in which, and you correctly pointed out, Roque is in some ways jurisdictional, but as you say, the parties in Roque didn't even file a notice of it. There was nothing. And the SJC in that case considered the appeal on the merits, I think for two reasons. One, because as someone has mentioned, there was no action on the motions for reconsideration. And so there was, or rather, there was no action on the appeal prior to action on the motions for reconsideration. And so there was no potential in that instance for for a judgment to be modified after the appeal was taken, right? You don't have that problem where you can have an appellate decision and then the trial court acts on another pending motion. That didn't occur. So that was one factor. And then the other factor, I think in Roche, it's alluded to, is that it was the issue presented in Roche was a fairly significant issue of personal jurisdiction in the Commonwealth. And taken together, that presented grounds for the Supreme Court to say, in the interest of justice, we're going to do this. So I do think that Roche is important. And I'm not sure that y'all does all that much to Roche. Y'all addresses another case, a different case, which is the Empire Loan case, which also addressed this issue and had a citation to Roche in a comparative way as a but C, but didn't purport to, Empire Loan did not purport to limit Roche. Empire Loan was decided on its facts in the opposite direction. So I think Roche is still operative. I think in the situation here, as you point out, to treat these particular appellants worse than the appellants who didn't do anything would be manifestly unjust, especially where this is a matter of broad discretion of the single justice. And really, to me, that's abdication of the judicial function. And I think when you read these cases, and by the way, Your Honor, it doesn't matter for the purposes of abuse of discretion if another result was possible. It doesn't matter, with all respect, if this court would have decided it differently on the record. What matters is whether the single justice's decision was arbitrary, capricious, whimsical, something that no judge acting intelligently could honestly have done. That's an extremely high standard to meet, and I think clearly there was no abuse of discretion here based on the totality of these circumstances and the situation in which we are all operating these days. I think the single justice was correct.
Do you think a mere misunderstanding of the rules can ever be good cause?
No, I think actually it can be good cause, and I think that's one of the things that Karen says. I mean, Karen Construction, which we cite, it says that the misperception of the rule of Rule 4C is not in and of itself good cause, but it can. There are circumstances in which it can lead to good cause, and I think this is one of those cases. So again, I'll go back to this notion. There are cases that go in both directions, and in trying to find a consistent line through those cases, Your Honor, I really came to the notion that courts in the single justice are going to look at these situations in the totality of the circumstances, because I don't think it's a binary function. And I think the cases stand for the proposition that it's not a binary function. There's play in this analysis. And as long as the single justice in the record before her had basis that's been recognized in the past, the decision should stand. And there are cases, the Troy Industries case, the Karen Construction case, and as you point out, Roque versus Molina, all suggest that no matter what any one of us might think of this, no matter what any one of us might agree or disagree with the single justice, as long as there was a legal basis and a factual basis in the record, then she did not abuse her discretion. And that is the sole issue for you to decide. And quite honestly, Your Honor, I don't think it's a hard question. I think cases, I think
it's a pretty hard, it's a pretty hard quest.
Well, I didn't mean that. I didn't mean that disrespectfully, Your Honor.
No, but it's right. This is a highly unusual circumstance, and it's obviously a tricky question we're all puzzling over.
It's a highly unusual circumstance, but I think the fact that it's a highly unusual circumstance is really part of the basis why the single justice did not abuse discretion here. I mean, there is language in the cases that are cited by both parties, to the effect that these are all close questions in one respect or another. But the single justice should not be disturbed as a matter of law unless that abuse of discretion standard is satisfied. And it's not enough for the other side here to say, well, we disagree. And and again, respectfully, it's not even enough if a reviewing court disagrees with the outcome. The question is whether there was basis in the record and the law, and then there is. And we cited cases that provide relief in the situations that we have discussed. One is Troy Industries, which has to do with lack of notice, and one is Karen, which has to do with misperception of the rules. Now, interestingly, the cases cited by Mr. Smiraj that he referred to at the end of his argument, Pierce, Shayev, etc., what those cases all say is that single justice abused discretion because there was no basis in the record. In one of those cases, I forget which, you get a situation where the lawyers went to the single justice and said, well, we had a miscommunication, but he thought I did it. I thought he did it. There was no explanation beyond that. And so the court said, well, there's no basis in the record. The record isn't strong enough. Here you have detailed affidavits of the lawyers involved laying out, and I would say painfully, what happened. The same is true of the Shayev case, where you had a situation where there was an affidavit from one lawyer that was actively contradicted by correspondence in the case. And the ruling was that it's not something that can be relied upon. So again, the issue is, I think always, whether there is a basis for the single justice's decision. And I think in this case that there is one. I think that's manifestly plain. And I think it would be very unjust to conclude otherwise, particularly in light of Roach, which, as you say, treated people who were, I would say, situated a little bit differently in a way that we should be treated here. There's no questions, Your Honor. I think I have 15 seconds, so I should probably stop talking.
All right, very good. The case is submitted. We will take a brief break and reconfigure our recording here and hear the merits of the appeal on the assumption that we are going to go forward with it.
I'll let you know in a moment. The case is now being recorded.
Good morning. Welcome back to the Appeals Court. I'm Justice Rubin, joined today by Justices Kinder and Ditkoff. The next matter we will hear is number 21-733, Tochi Building Corporation versus IR4 Partners, LLC. And the rules when we hear argument by video conference as we are today due to the ongoing pandemic are the same as in our courtroom. It's 15 minutes per side, and there is no rebuttal. And we will hear first from, Attorney Donahue. Is that right?
Thank you, Your Honor. May it please the court, Michael Donahue for the appellants, IR4 and Boston Harbor Industrial Development. So this appeal, Your Honor, arises from a summary judgment and entry of separate and final judgment under Rule 54B on a breach of contract count in an underlying case between our clients and Tochi Building Company, which is a general contractor. It involves a construction project at 645 Summer Street in Boston, which is an office building, sort of looks like a warehouse. It's 3 stories. I will not bore you with more construction details. except to say that our clients engaged Tochi, or our IRIV engaged Tochi, to act as general contractor for the project. In 2016, work went on and up into spring and late summer of 2018. At that time, Tochi was significantly behind in the progress of the work. Our client, IRIV, issued a notice to Tochi that it was in default for failing to advance the work sufficiently to a point that would allow our IRIV to enter into its lease for some of the portion of the building, tenant space for 908 devices. And that started this dispute in earnest.
Now, we are very familiar with the facts, and there isn't that much time here, unfortunately, because this is, unlike the last appeal, which has one tiny issue in it, this is a big and complicated matter. Can I just draw your attention to one point, and it's raised in the amicus brief that we recently received that I assume you all have seen. And it's about this statutory requirement of certification. And I'm trying to figure out whether that's a big deal or not a big deal, because it seems clear that even if we were to find a number of things that IR4 did to be otherwise valid rejections within the meaning of the statute of payment requests, and obviously we're going to have to go through each email and each writing and try to figure out what's what. None of them contain this certification, certified as made in good faith. And I'm trying to figure out, is that a big deal or not a big deal? So can you tell me?
Thank you, Your Honor. Yes, I can, and I hope I will. Well, I don't know if I would couch it in terms of whether it's a big deal or not a big deal, but I think what you're referring to is the amicus brief filed by UCANE and SIM, which points out, as we do in our brief, Your Honor, that in construction contracting, particularly in private construction contracting, although this is also true on the public side, notice provisions, such as the notice provision in the Prompt Pay Act, are enforced, but they also are enforced in a way that recognizes that substantial compliance is what really matters. So as long as actual notice is received and there's no prejudice from the lack of a technical notice, we don't consider the notice defective as a general rule. And that is also true in matters of the public bid law. There are
But I don't see any place else where there's this requirement, and I don't even know what this certification means. I mean, does it mean it's under oath? Does it mean you get quadruple damages if you weren't acting in good faith? Like I'm not sure what the substance of it is, but there it is in the statute. It says that a rejection, whether in whole or in part, shall be made in writing and shall include and shall be certified as made in good faith. I don't know why. Do you know why the legislature put that in? Do you know what its legal effect is? I'm trying to figure out whether it matters. You call it substantial compliance or not substantial compliance. Clearly, this certification did not appear in any of the writings at all, clearly. But I don't know if that means, oh, come on, everyone knows it was in good faith, no big deal, substantial compliance, or what the purpose of this is. And of course, I'll ask counsel for Tochi as well.
Well, Your Honor, I struggle with that question as well, because in the first instance, the parties in any contract are governed by an obligation of good faith and fair dealing. So any action under a contract is legally supposed to be done in good faith. I mean, there's a temptation. This requirement to me is more of a trap for the unwary than a substantive thing. And I can't say why the legislature put it in there. I don't think that's really indicative in any of the legislative history. You have the testimony in the amicus briefs of Ms. Lawton before the legislature, and I don't think she talks about it at all. You know, it is somewhat of a carryover from public construction statutes that talk about certifications on demands for direct payment and things of that. So there may be sort of a notion to have this be equivalent. But I think in the public.
Yeah, what is the consequence in that context what is the value of that certification to the recipient? And what is the consequence of an absence of such a certification in that context?
Well, quite honestly, Your Honor, I'm not aware of a case that addresses it. I think we'd be having sort of the same argument. I mean, and back to my original point, there are any number of cases having to do with the public construction statutes, where formal technical defects in notice are overlooked or they don't really cause any harm. And I don't believe that the failure of a certification of good faith causes any harm. If the point of this statute, in part, is to make people communicate about payments and prevent certain people from simply not acting on payments, then that point is satisfied by a notice telling someone, A, you are not going to be paid, and B, this is why you are not going to be paid.
But it seems to me that you put in something like that because you think people have been doing something in bad faith, right? You think, look, we have to make sure they certify it's in good faith because people monkey around with this and they do it in bad faith. So they'll certify it's in good faith. Now then, I don't know what happens. I guess if a lawyer certified something was in good faith and it wasn't, they could be disbarred or something. Maybe that'd be a lot worse than just saying we reject, although these notices don't have to come from a lawyer. I'm just trying to figure out what the consequence is, because I don't think we're free to read it out of the statute. And to some extent, your suggestion is it doesn't do anything.
Well, I think for practical purposes, Your Honor, it doesn't really do anything. I mean, it's a box you have to check, according to the statute, certainly true. But I don't know, as you say, I don't know if there's a substantive impact from it one way or the other. Now, I suppose you could conjure up a situation in which people do act in bad faith and in which people are making things up and in which people are, acting unlawfully and otherwise doing things they shouldn't. But that is why we have courts, and that is why we have the ability to sue, and that is why we have breach of contract and all kinds of other things. So I'm not sure that a failure to affix this certification is sort of ipso facto the kind of a statutory violation that should lead to, in effect, a windfall. I mean, because it really is a gotcha.
Well, it's not. Now, let me also ask you that. And this really, I'll ask your brother, why is it a windfall? That is all that has to happen. I understand that people may receive money and then spend it, and you may not be able to get it back. But if we say you still have all your defenses, but you still got to keep the cash flowing because there's work, it's periodic payments. You've got subcontractors relying on this. People are purchasing goods that are being used on your project and so on. And this is to make sure they don't go out of business. And so we're going to keep the cash flowing, not saying that later, even in 10 hours later, you can't file some kind of claim. Not that it's a waiver of your substantive objection to paying, but you got to pay right now and you'll have to get your money back later, or you know what I mean, or reduce the final payment or whatever, or bring a contract action or something. Why is it a windfall if really all it's doing is keeping the money flowing for now?
Well, it is a windfall because to hold that would be to do the opposite of everything that you just said. I mean, in construction contracting, you probably will know, this is a periodic process, and owners and general contractors have rights downstream to claw back and to otherwise assert rights for payments that were maybe made improperly or shouldn't have been made, or there's a defect or something arises. And to say, you're entitled to automatic payment because of this technical failing does two things. One, it imposes an obligation that is not present in the statute. This statute does not say if you fail, the person is entitled to immediate payment. That's a matter of contract, whether someone's entitled to be paid, whether or not a payment application is approved or deemed approved. And so if we hold with the proposition that the owner of the general contractor retains its rights with respect to payments that are made or payments that are approved.
I don't get that. The statute says that you have to agree that anything you approve, you pay within 45 days. And you're telling me that that doesn't mean you have to pay the stuff you approve within 45 days?
Well, what the statute says, Your Honor, is that the contract can't have a payment period that is longer than 45 days, right? And so that is not the same as an absolute obligation to pay. What's the
difference between a contract that says that you will pay everything you approve within 45 days? Actually, I don't even have an answer. I don't even have a continuation of that. I mean, if you're agreeing to pay within 45 days, why don't you have to pay within 45 days? The stuff
Well,
you
as a matter of contract, Your Honor, you absolutely would. But that involves a question of whether a failure to pay an approved amount in 45 days is in fact a breach of the contract. And there are situations in which it is not, because the owner and contractor, as the case may be, have rights after the fact based on things that arise. So in this situation, or in a situation where you're at the end of the job, for example, let's look at that. The owner has rights to claw back amounts that shouldn't have been paid in the first instance. And if you want to
But that
analogize,
doesn't mean that the failure to pay in the first instance wouldn't be a breach of contract.
it might make it an excuse breach, or it might make it a breach without consequence. In terms of the statute.
But it would be a breach. You're supposed to do it, right? Approved amounts are to be paid within 45 days under the terms of the contract mandated by the statute.
It doesn't necessarily mean you're supposed to do it, Your Honor. The contract may give you rights to not do it with respect to approved payments.
I don't understand that. Then what's the point of the statute?
Well, the point of the statute, even according to the associated subs, is to return leverage to subcontractors. And by the way, the statute is not rendered toothless if the court recognizes that someone's right to payment is a matter of contract, because the statute also contains language which renders no stop work clauses and pay when paid clauses legally ineffective. So in this instance, for example, if you had a periodic pay application that was considered to be deemed approved by operation of statute, that would create the right in the subcontractor, or the contractor, in this case Tochi, to stop work or to terminate the contract, which did
If
not
they
happen.
weren't paid, because you had an obligation to pay under the contract.
If they weren't paid, Your Honor, that's correct.
But that's because you had an obligation to pay under the contract.
Yes.
Okay.
But then it's a matter of whether that obligation arises and how it arises. And my point is that it arises as a matter of the contract itself. And in this case, the contract itself talks about the owner's right to approve, reject, or nullify previously approved payment requisitions if certain circumstances arise, such as the situation in this case. So the statute itself doesn't impose a payment obligation. And contrast that with Chapter 30, Section 39K, which in fact does, in the public realm, say the owner shall pay. That language is not present in the Prompt Pay Act. So the legislature clearly knew that it was able to say that if it wanted to, but it didn't say it in this case. So this is all a matter of whether the contract was breached, Your Honor. And what you have here is each party saying the other breached the contract. And on summary judgment, on the record before this court, there was not enough in the record to conclude that Tochi had satisfied its burden of proving that it performed the contract in every respect and didn't breach it itself. And that's what would have had to happen for a summary judgment to enter, let alone entry of judgment under 54B, where you have competing claims of breach of contract, and you have quantum error, you have tort claims, all arising out of the same set of facts. And you have countervailing claims for damages, which I would point out, I believe the position of the associated subs, and I believe the position of Tochi up to a point, was you can pursue those claims down the road. It's just the record didn't support what the Superior Court did. Even if that was, I would suggest to you, even if that was an appropriate interpretation of the statute, which we contended it was not.
Okay, this case is very well briefed as well as being well argued. So we have all of your arguments. Your time has expired unless there are further questions, which I can imagine, but nope, I see none. We will hear now from you, Attorney Croft.
Thank you, Justice Rubin. Bradley Croft for Appellee Tochi Building Corporation. May it please the court. This case is exactly the type of situation where an owner, without providing a contractual, factual, and good faith basis, withholds payment indefinitely from a contractor. This is exactly what the Prompt Payment Act was designed to prevent.
Can I ask you a couple of what I think are tough questions? Maybe they're not, maybe it's easy.
Sure.
Let's say a contractor has, a project owner has a perfectly good defense to payment, an actually perfectly good defense to payment that they know about. But this is double billing, but he says that they worked all these days and we know they never came in, or they were supposed to put in bathroom fixtures and these are useless. Some perfectly good defense, but they don't raise it and they make a payment. Let's say they don't raise it, and by operation of law, the payment becomes due and they make the payment. But they think you breached the contract. Maybe they even think you committed fraud, double billing, didn't show up for work, didn't do good work. Can they still sue you for breach of contract later and try to get some of that money back?
Absolutely.
So nothing is waived except the timing of the payment. They have to pay the money over and then try to get it back. And that is all.
That is the Prompt Pay Act. All it does, it's very narrow in this regard. It imposes reasonable contractual limits within which and by which an owner must act to reject a payment application. That's it. It doesn't limit an owner's right to recover for defective work, for overbilling, for fraud, for any
even if they know about it. Don't raise it in a rejection and make and therefore it's deemed approved and they make the payment.
Correct.
You are not saying, and that's the end of their claim about the work during that period, even if they knew about it, okay, great. So that actually helps me a lot. Let me ask you about the certification.
Sure.
So there may be some, we'll have to look through all of the emails and the backs and the forths and whether they contain anything. But none of them contains a good faith certification. On the other hand, it seems clear from the facts surrounding these that there was a genuine dispute going on that's still going on about how many workers were provided, about whether things were done timely, all of this kind of thing. I don't know.
So
what is the injury? All right, so there's no certification.
Sure. I'm happy to address that, Your Honor.
Yeah, let's say they had given you a beautiful rejection. That
gets
absolutely met. It said under the contract, it says you will do it timely and you didn't. And we are withholding the payment because the things were not done right. And you have to under the agreement. And that's what we're doing. It's a rejection. It doesn't have a good faith certification.
But you don't have the certification in good faith.
Yeah.
Okay. Then this gets to the heart of this statute, Your Honor. For the age-old problem that this statute addressed, which it was when owners would allow contractors to perform the work, in fact, expect them to perform the work, and then withhold payment. And this certification is something that is not a ministerial box checking. This gets to the heart of it because what this statute does is it imposes on the parties an obligation to, in a timely and in a thoughtful manner, whenever they get a periodic progress requisition, to read it, consider it, and if they have grounds not to pay it, to reject it. And there are three elements. They have to reject it within a certain period of time. They have to explain the factual and contractual basis, so it can't just simply be a rubber stamp rejected, and shall be certified as made in good faith. And those words, shall be made in good faith, are so much more than ministerial. Those words are not how something is rejected, they're why. It's the rejection itself. It shows that the owner, it's the I really mean it. That is what that conveys. So another part of this statute, which is critical for general contractors, is when they receive that rejection, they need to be in a position, because this law applies to a general contractor paying subcontractors as well. So the general contractor needs to be equipped with those same factual and legal reasons why they're not going to pay, for example, the electrical sub. Because the owner said, here are the issues we're having with your electrical work, and here's the amount that we're withholding on account of those. So to get to your honor's point, and it is very telling, and I urge this panel to go back to the record. And in fact, go back to IRIV's appeals briefs. They've submitted 124 pages of appeals briefs in this case. And there is not one mention of a document or an attempt, whether substantially complying with it or technically complying with it. There's not one mention of it anywhere in their appeal briefs. So to the extent that and I think this probably would also assist the court.
You're saying that it has to, that this certification isn't ministerial, doesn't
correct
make it not ministerial. Okay, so let's take this example. On September 28, 2018, IRIV sent Tochi a list of deficient work with photographs. Okay, bunch, you know the document I'm talking about, presumably. It has a bunch of photographs.
Right.
Okay, and then on October 11th, they sent an email that said Tochi has just sent a PCO for close to $500,000 on the job after I had asked repeatedly since July if it was entirely accounted for. I'm not confident in the accuracy of cost management. There remain deficient, incomplete, and uncoordinated work. Accordingly, I require the requested information to which IR4 is entitled to properly assess the outstanding requisitions. Okay, now it's not structured like the statute says.
Correct.
But one might read that to say, there's a lot of trouble on this, and yet you've sent me a brand new $600,000, whatever it is, periodic payment request. I sent you those photos, remember, of the deficient work, and I haven't heard from you on that. In order to figure out, in order to assess the validity of this requisition, this periodic payment request, i.e. before I can pay it, I cannot obviously pay it without assessing it. I understand it's not written beautifully from the standpoint of the statute. I need to have this and this and this. Now, a smart person working for Tochi would say, oh, he can't assess my requisition. And he says, I haven't addressed deficiencies. And oh yeah, 2 weeks ago, he sent me 48 photographs that he says show inadequate work. Now, one might say, oh, that shows good faith. There's photographs. He says these aren't real. He's not just making this up. Now, maybe the photographs actually show excellent work, or maybe it's all been fixed since the photographs or something. But I'm trying to figure out what adding the phrase, and I certify that my concerns are made in good faith, what benefit that is to you or what detriment it is to him, that we should be saying, I'm sorry, this isn't good enough. What you need is the words certified in good faith. And I understand the statute says it, so we could just say, and that's it, and we're not going to look into it. But it seems like when they've sent you photographs of work they say is deficient, it's not a mystery anymore what you're talking about.
So Your Honor, I believe, on a construction project, remember, this only applies on jobs where the base contract is $3 million and up. So on these jobs, there are photographs being sent daily. There are emails being sent daily. There are constant complaints, get more people here. You got to do this over. They're constant correspondence. What this does is when a periodic payment requisition lands on the owner's desk, it mandates that the owner must specifically pay attention to that payment requisition. You can't simply refer in general terms to, you've asked for a lot of money, we're not going to pay you a lot of money because we have these issues out there. It puts forth a very specific, and by the way, Your Honor, all we're talking about is a certification that says, I hereby make this certification in good faith. You don't even have to be right. Your reasons for withholding payment don't even
I feel like you're not answering my question in this case, in this context. And I'm not talking about all other requisitions. I'm talking about this one email that says, in order to assess your requisitions, and I take it it's referring at least in part to requisition number 24. I think that's what it means by a PCO for close to $500,000, although I'm not sure, partly because I'm not sure I know what a PCO is. But well, maybe you can tell me.
Well,
so,
that's exactly right, and that's exactly the point here. Is that is not a rejection of a pay requisition. That's simply a response to the status of construction work.
what is a PCO?
It's a potential change order.
That is not a reference to the requisition number 24.
That's correct. That's correct. And in fact, Your Honor.
Counsel,
Sorry.
what about the November 8th letter? It specifically says we're rejecting and nullifying payment applications. And it goes on for pages explaining exactly why. And it's signed by a lawyer. So you at least have the implicit lawyerly certification.
So on that letter, Your Honor, it comes about 5 months late for most of the payment requisitions.
Sure. Won't apply everything.
Sure. Okay. So the reason why that one does not comport with the substantive requirements is, in fact, in that letter, it does not refer to a single payment requisition. So the owner sends that letter to a general contractor. How is the general contractor supposed to take that letter and communicate any specific reasons to its subcontractors as to why they haven't been paid for 5 months worth of their own requisitions that they've provided to the general contractor? Again,
well, it says it's nullifying the current payment application, and the only one that was current or within the 60 days was requisition 24 at that point. So what's the mystery?
Well, again, he's saying I don't have the letter right in front of me, but nullifying the other requisitions that have come thus far. But that letter in and of itself, again, and by the way, simply because it's sent by an attorney, the contractor is held to the certified in good faith standard. If Your Honors look at any of the payment applications which are part of the record, there's a requirement that the contractor, in order to get paid, needs to certify in good faith that its payment application, its requisition, is being submitted in good faith. There's no fuzzy, it almost does, it doesn't, oh, a lawyer signed it. This is a specific requirement. And then the architect, in order to certify payment, also has to certify that he or she is certifying that payment is owed in good faith.
What happens if they don't? What if they say it and they're lying? Is there a penalty?
If the architect is lying?
Anyone does one of these certifications.
Sure.
I mean, I'm trying to figure out how it protects you. And I understand in lots of circumstances how it protects you. This is the only notice you get. But you have an ongoing conversation in this case between the contractor and the project owner, where at some point it begins to become clear what it is the owner is objecting to, wrongly or rightly. At least it's becoming clear. And my question is, are we supposed to say, and yet it doesn't say certified? I'm not saying we're not supposed to, but I'm trying to figure out why. Why, right? If it said, and it shall be on blue paper. I mean, even then you might say, well, that's so everyone will know that it's the thing. It shows up, it's on blue paper. It's the blue notice, right? Maybe we'd say it's no good.
The SJC has said that where the language of a statute is plain and there's no room for speculation as to its meaning or its implication, meaning where the language of a statute is plain, there is no room for speculation as to its meaning or its implication.
I just wonder how many lawsuits we're going to see where perfectly good rejections were sent that didn't have a certification in them. And suddenly someone says, oh, you were supposed to pay me last year. These 18 payments, because it didn't have this word in it, even though you knew and we knew that we were having a dispute about, a genuine, legitimate dispute about something. And I'm not saying we shouldn't do that, but I still haven't heard what the benefit is.
The benefit is that it ensures from a owner's perspective all the way down that there was a deliberate going through, a methodical going through of the payment application that was submitted, and that it wasn't just rubber stamped. This is not like those cases where the owner has cited saying, oh, courts have looked over, looked past this type of ministerial act because a bond claim wasn't sent by certified mail. That goes to how something is sent. It doesn't go to the substance of it. This good faith requirement is what contractors and subcontractors who are in the position now of funding and financing, in this case, they haven't been paid since 2018, $5 million. And the owner is holding those funds and it still has its rights.
Well, okay. I mean, I see what you're saying. I have one other, your time is expired, but I have one question for you about requisition number 21. And this is the one in which only $143,000 were withheld. And this is for Tyson and general conditions and general requirements. That's what it says in the email. It is clear from the email back and forth. I don't know. Do you know what I'm talking about? Do you know which?
I know the application number 21.
Okay, so it was for $1 million, and IR4 sent an email that was withholding $143,000, and there's an email exchange about how are you calculating that, and someone says, oh yeah, it's this and this add up to that amount. It's these two lines or whatever. And so it's clear that there was some oral or other conversation that we aren't privy to. You read the email and it's quite clear they've been discussing this 143,000 or these two line items or something, but we don't know what. Just not good enough because it's not in writing?
It's not in writing. It doesn't specify the basis, and it's not certified as being made in good faith.
I understand.
It's not a heavy lift. All you have to do is include those 4 words, and you technically would have complied with the statute, nor do you even need to be right. So that's a perfect example of what the legislature intended here, was to give a clear notice of a very limited, by the way, Your Honor, even all of those examples that you just cited. If in fact the owner claimed that it still had problems with the construction, it had the opportunity in every one of these requisitions to have raised those issues and withheld payment based upon those issues. It didn't. So all of this is the consequence of failing. I mean, the statute provides 2 separate opportunities for an owner. It intrinsically has a clawback provision.
Okay,
where
your time has expired, but I've spent a lot of time asking you about certification. If either other judge wants to ask about something, I know. All right. Thank you very much. Very well briefed and argued by both of you. Obviously, it's a complex and interesting case, and it is submitted.
The case is now being recorded.
Good afternoon. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Kinder and Ditkoff. Our last case of the morning is afternoon now, is number 21-420, Commonwealth versus BRIDDON. Our rules for argument when we hear argument by video conference, as we are today due to the ongoing pandemic, are the same as those in the courtroom, which is to say 15 minutes per side and no rebuttal. And we will hear first from you, Attorney Essington.
Thank you. Good afternoon. May it please the court, Catherine Essington on behalf of Jason BRIDDON. Trial counsel here was aware of sworn alibi testimony presented in Mr. BRIDDON's first trial and took no action to present it to the jury in his second. Judge Wren erred in denying Mr. BRIDDON's motion for a new trial following a remand from this court. Judge Wren's decision is entitled to little deference because he was not the trial judge in either of Mr. BRIDDON's trials. Mr. BRIDDON, however, does not dispute Judge Wren's finding that had his ex-wife been called as a witness in the second trial, she would have invoked her Fifth Amendment privilege. Nor does he dispute Judge Wren's finding that had she invoked her Fifth Amendment privilege, she would have been unavailable as a witness and her prior testimony would have been admissible under the prior testimony exception to the hearsay rule. What Mr. Bridden does take issue with is Judge Wren's finding that his second attorney, David Giannetti, would have violated the rules of professional responsibility had he sought to introduce her prior sworn testimony in the second trial. Judge Wren's decision assumes that Wendy's testimony at the Martin hearings was truthful and that her testimony at the first trial was not truthful. That was not a determination that Judge Wren should have made. Judge Wren instead should have determined the impact or the likely impact that her prior sworn testimony would have had on the jury in the second case. Attorney Giannetti would not have known whether Ms. Bridden's testimony at the first trial was truthful or not. At best.
Counsel, let's say that's true. We go to a second trial and wife is called, wife claims the fifth, Martin hearing, judge decides that the witness committed perjury in the prior testimony, but defense counsel doesn't know that. Does the judge just allow that testimony in at the second trial, or does that judge have some obligation, the judge itself, to prevent testimony that the witness who gave it now says is perjurious from being admitted?
I think that the testimony comes in at that point, and as I indicated in my reply brief, I think as a practical matter at that point, if the prosecutor wants to put before the jury that the witness is now recanting, that they can certainly offer immunity to the witness. But I mean, I think that the judge's determination in the Martin hearing is not necessarily that the witness actually committed perjury. It's a determination that the witness has a valid Fifth Amendment privilege.
We don't even know, and certainly the parties are not entitled to know what the basis of that finding is.
That's right.
I mean, it's not, I mean, all we know, all the Martin hearing tells anyone observing it is this witness is unavailable, having invoked the privilege, right?
That's correct, Your Honor.
Now, the Commonwealth could, and I suppose likely would, although we'll ask opposing counsel this question, grant immunity to find out what's really going on, but that hasn't happened in this case.
That's right. I mean, we're obviously,
I mean, even, am I mistaken? Could that have been done below during the remand hearing here? That is, could the Commonwealth, I don't know what the procedure is, but could the Commonwealth, rather than having this go through a Martin hearing, could they have immunized the ex-wife to find out what she would have testified to?
I don't see why not, Your Honor. Yeah, I don't see why not.
Can I come back to Judge Ditkoff's question from a fairly slightly different angle? Let's assume in the course of the Martin hearing, the judge reaches a conclusion based on what he's been told that there was perjured testimony in the first trial. Doesn't the judge then have some obligation to make certain that perjured testimony is not put before the jury?
I don't think that that's a determination really that properly the Martin hearing judge should make. I mean, I think the determination is only limited to, does the witness have a valid Fifth Amendment privilege to make that witness unavailable? I don't think that the judge needs to determine whether the prior testimony is in fact perjured, just that the witness has a privilege. Again, I think part of what occurred here that was error was that Judge Wren went beyond what he needed to find and implicitly found that the testimony was perjured, but that's not an appropriate determination for particularly the motion judge on an ineffective assistance claim to make. What the motion judge should determine is what the likely impact of the testimony would have been on the jury, whether it likely would have affected the outcome, not whether the witness is credible now or was credible then. That's an inappropriate determination for the motion judge to make in those cases.
Is there any impeachment available to the Commonwealth in a circumstance like this? I find this a very confusing case for the reasons Justices Kinder and Ditkoff have suggested, which is there's this kind of behind a veil box, and I don't want to even say that what that box might contain, but it's weird that there is this box and someone knows something that they otherwise wouldn't know, because we don't let people just say, I take the fifth. They sometimes have to show something. But my question is, could the witness be impeached? She's not a criminal defendant. Could the Commonwealth tell the jury this witness has taken the Fifth Amendment?
And to the latter question, no. I think the case law.
Why?
I think the case law is clear that it's inappropriate to put that in front of the jury, because I think
even though it's just a witness, she's not going to be prosecuted. Nothing's going to happen to her as a result of it.
Right, but I think the case law makes clear that it's not appropriate for the jury to hear that, because witnesses could be taking the fifth for a number of reasons, and that the jurors might assume, make false assumptions based on that information. So again, I think what would have been available to the Commonwealth if they wanted the jury to hear that she was, recanting, walking back her prior sworn testimony, would be
if she was, we don't know that she was, but if she was, yeah.
Yes.
If they want to know what she's doing, they could immunize her.
Correct. But I think the prior sworn testimony clearly is admissible. And in fact, Judge Wren found it to be admissible, and the Commonwealth conceded that her testimony would have been admissible in their supplement to their opposition, which is in my appendix. They appear to be trying to walk that concession back a little bit in their brief by arguing that the judge has some kind of gatekeeper function, but they did concede that in their opposition, in their supplement to their opposition. So again, that.
Counselor, besides what Judge Wren may have let slip out, did you and your friend have any knowledge of what the basis of the fifth was coming into these hearings?
Not at all, Your Honor. I mean, I think I indicated in my brief that I sent an investigator to try to speak with her. She would not speak with him. And I was not sure, honestly, what would happen when she came to the courthouse. I was not even aware that she would assert or fail. She came with her own lawyer. So it was unknown to me what would occur. Just in terms of the last prong of the ineffective test, I want to emphasize that Mr. Bridden has shown prejudice here. I think this case is really controlled by Diaz-Perez. It's very similar procedurally. You have an instance with a first trial where a witness testified and the result was a hung jury, and you have a second trial with a different lawyer who did not attempt to interview the witness or call the witness or introduce the prior testimony. And the motion judge in Diaz-Perez allowed the motion for a new trial based on ineffective assistance in that case, and the SJC affirmed. Again, the test, I want to emphasize the test is not, would this 100% have resulted in Mr. Briddon's acquittal? The test is, would it likely have affected the outcome of the proceedings? And as in Diaz-Perez, this is not completely hypothetical, because we know that in the first trial where her testimony was presented, that it was a hung jury. So we have two different, and that is a different result than a conviction, obviously. Also, you know, one of the differences between the first trial and the second trial in this case was that in the first trial, the Commonwealth called the aunt of the complaining witness who corroborated the victim's timeline. That witness was not called in the second trial for reasons that are not clear to me. But again, the second trial was really a he said, she said situation where there was no corroborating witness for either side and no physical evidence in support of the charges. And it was not a particularly strong case where you have a complaining witness who was heavily intoxicated and described her assailant as 5'6", whereas Mr. Briddon is 6 feet tall, and, you know, gave inconsistent descriptions of his vehicle, of the place where the assault allegedly happened. This was just not a strong case for the Commonwealth. The Commonwealth is somewhat attempting in its brief to relitigate this issue of deficient performance, but this court in the previous appeal has already decided that issue, and that is res judicata and the law of the case. This court said that Attorney Unetti's evaluation was not reasonable of the difference between presenting alibi testimony that might have some weaknesses, but versus not presenting any alibi testimony at all. So again, this court is really just examining the prejudice prong here. And we have Judge Wren saying that the prior testimony would have been admissible, and the Commonwealth conceding that the prior testimony would have been admissible. And I would suggest under those circumstances, Mr. Briddon deserves a new trial. And again, the test is, would it likely have affected the jury? And he's met that test.
Counselor, you mentioned in your brief, you say in your brief, the wife expressed a desire to counsel's investigator that he stay in prison. Is that in the record anywhere?
No, Your Honor. I mean, that's what I was informed by my investigator, but he did not. There was really no way to present that as part of the record.
Okay.
Thank you. Unless there are any other questions, Ms. Briddon respectfully requests that the court order a new trial. Thank you.
I see none. Thank you very much. Excellent argument. We will hear from you, Attorney Haran.
Good afternoon. May it please the court. Donna Heron on behalf of the Commonwealth. Judge Wren in this case properly denied the defendant's motion for a new trial where the defendant has failed to establish he was deprived of substantial ground of defense, given that Wendy, the ex-wife, provided untruthful testimony during the defendant's first trial. This court remanded the case back for a finding of whether, and instructed in its 128 or in its unpublished decision, what her availability would be as an alibi witness and the potential and value of her testimony. And that is what Judge Wren did when he held the two hearings, Martin hearings, with the witness. And he made findings of fact that she would have, based on sworn testimony under oath, that she would have invoked her Fifth Amendment privilege at the retrial, and that she gave untruthful testimony at the first trial. He makes that. Well,
we don't know anything about how it was untruthful, and I don't know that it's proper for a judge to tell us anything at all about what happens in a Martin hearing. Do you? I mean, it isn't the only proper outcome of that hearing that she's unavailable. She has legitimate Fifth Amendment claim and she is unavailable.
Based on your order, he did what you asked him to do, which is to hold an evidentiary hearing and then to make findings of fact. And I would suggest to this court, maybe he shouldn't have told us that she lied. That's what he said. He said she lied during her first testimony, his first trial.
Okay, but we don't
whether
know.
he technically should have done that under a Martin hearing or not, that was the findings of fact as based on the credibility judgments he made that he found.
Okay, but none of us know what the scope of that, what that means exactly. And I don't know how he's able to determine it based on a Martin hearing where there's no cross-examination, there's no adversary process for determining the truth. All Martin hearing is, which is of course ex parte, is to determine whether the person has a valid Fifth Amendment claim, and apparently the ex-wife does. So now, let's say we have to not look at some finding of fact made in a non-adversary secret hearing, and we have to just say, okay, so she has a valid claim. What should happen then?
I mean, quite frankly, Your Honor, there's no other Fifth Amendment privilege she has other than perjury. There's no allegation that she was anywhere near the crime when it occurred. Quite frankly, there's no other potential Fifth Amendment privilege.
Maybe she was smoking marijuana at the time.
How would that provide a Fifth Amendment? I mean, I guess the
or cocaine. I mean, it's actually a crime.
I didn't
cocaine is a crime. I mean, it could be anything. Could give you a Fifth Amendment. That's why we have Martin hearings.
Yes, and Judge Wren, whether you agreed he should have or not, has determined the Fifth Amendment privilege was perjury because she provided untruthful testimony at the first trial.
Okay, well, why don't we just say, what if we were to conclude that without an adversary proceeding, he was without, that's a meaningless finding. There's been no cross-examination, who knows? So my question to you remains, let's pretend the judge did this right and simply found, oh, I find she has a Fifth Amendment claim. Then what is supposed to happen? I mean, it's an unusual circumstance I've never seen before. What's supposed to happen? Now we have an unavailable witness. We have her prior testimony. How are we to figure out what should happen next?
I guess the way I look at it, Your Honor, at that point, as you said, that the defense counsel should have contacted the wife. Now we know, had he contacted the wife, she would have told him, or there would have been a Martin hearing, she would have been summoned then, she would have had a Fifth Amendment privilege. And if we go down this road of speculation, then he would have tried to offer, and I'm not conceding ethically he should have put the thing in, which I think is a distinction that my sister's missing. I get under the rules of evidence, it's a prior recorded statement. I understand that. But the Commonwealth is not conceding that it should have come in wholeheartedly, because I think at that point there'd be grave concerns regarding the truth of the statements. But
okay, but this does happen all the time, right? All the time someone pleads the Fifth and now their prior testimony comes in, and there must be grave concerns all the time about letting that in. So what happens? What's supposed to happen?
I guess at that point, as mentioned, we go down this road of speculation. The Commonwealth most likely would have immunized the witness. Then she would have testified that she lied during her first trial.
But you haven't immunized her.
But you asking me what would have happened, that's what would have happened. But we have what Judge Wren did, which is what you have her transcript. So clearly I'm behind the 8 ball of knowing exactly.
No. I'll let you know. I haven't listened to the recording. I haven't looked at a transcript.
Well, I should say, I see that the court has ordered and it has been produced the 2 Martin hearing transcripts. And under the Pixel case, you guys the appeals court is allowed to read those transcripts.
I understand that, but I'm asking what's supposed to happen. So now he goes and you did not offer to immunize her at the new trial hearing, right?
No, that was not an option that was raised.
All right. So now if we were to reverse here, and say, well, he's allowed to introduce this thing and then the Commonwealth can decide what it wants to do. My guess is, although I have no idea, that you will in fact immunize this witness, because it seems to me the odds of you prosecuting her for anything, not that I know what she did, seem very remote to me, but I may be wrong. That's up to you all, right?
Yes, we would immunize, obviously we immunize her because as he found, she lied during her first trial. That is what her perjury is.
Well, you
as
could
Judge Wren found.
prosecute.
She
Okay.
has
you
perjury
might-
charges facing her. We would immunize her for perjury. So then defense counsel, I would suggest, would not put someone on the stand who's now going to testify. I lied during my first trial. He was not home when I said he was home.
Well, you all could figure out what she actually was going to testify to, right?
I guess if this court wants to remand the case back to have an evidentiary hearing in which we'll immunize the witness and to
Well,
find
are you
exactly what she
representing
would have
the,
testified to.
are you, I don't know why you're so angry, Attorney Herron.
Because I guess looking at the case law, it's about, I know that is not preferable that Judge Wren told us that she testified that she lied during the first trial. I appreciate that technically he was not supposed to do that, but we are where we are. And we have a witness who now has said, I lied during the first trial. And where the—
We don't know what that witness, I'm sorry, we don't know what that witness said. All we have—
because Judge Wren told us what she said.
I don't
sorry,
know.
Justice Rubin, he did though. He told us in his order that she provided untruthful testimony during her first
You
trial.
don't know what aspect of her testimony might have been untruthful. You don't know anything about it, right?
We do know that he found that when you take out the untruthful parts of her testimony, it would completely undermine any credibility and render her testimony inadmissible. That was his finding of fact. So whether we should or should not have known, we do know that now. And the core basis of this court is, as I cited in the Levy case, is judicial seeks the search of truth. And defendant is arguing, I want to put in her first testimony at her first hearing regardless. And I just don't think when a witness under oath testifies that they have lied during a trial, that
We
is an
don't
honest
know
administration
what she
of justice.
testified. I appreciate that, but we don't know what she testified to. She certainly wasn't cross-examined. But let me ask you this. Are you representing that the Commonwealth, if we remand it, the Commonwealth will immunize her? Is that what will happen?
Most likely, yes. I mean, I would have to, I don't want to say a blanket 100% yes, but because I would obviously have to run that. I can't myself offer that. It has to be run up by my senior first assistant and people who make way more money than I do. But yes, most likely.
I don't know about way more, but.
Unfortunately, yes, but yes, most likely, because again, reading what Judge Rudd found that she's going to testify, I lied during my first trial. When I gave him an alibi, I lied. Because as reading into the findings of facts he made, that is what she will testify to. So yes, the Commonwealth would.
Counsel, let me ask you this. Let's assume that some part of that the wife's position is that some part of her testimony was perjurious. That's what Judge Wren tells us, and I agree he shouldn't have, but we got that. And let's assume that we don't agree with the position that this made it unethical for the attorney to introduce this testimony. If we get there, then what do we do?
Again, if you go down the road, I guess, of speculation, which or whatever.
You tell me what road I should go down. Let's say I get to the, I say what Judge Wren wrote is wrong. It would not have been unethical for Attorney Yannetti to introduce this evidence. And that was the basis of the decision. So I've decided that's wrong. Then what do? I don't have to go speculating. You tell me what my ruling should be if that's where I get.
We go back to 2012. If Attorney Yannetti had done what he said he was going to do and called her, she would have informed him, I'm not going to testify for him. I'm going to have a Fifth Amendment. I'm going to assert a fifth. We go to trial. He summons her in. She asserts her fifth. At that point, he's faced with the decision. What do I do at this point? Do I introduce this testimony with all the problems? And I'm not trying to relitigate your initial finding that he was ineffective, but I do believe at that point, you can go back to the reasons why he also, in the original motion for new trial, did not want to introduce this testimony. He didn't find it extremely helpful to her. And now he's going to also consider the fact that most likely, if I try to admit this, the Commonwealth's going to immunize her and put her on the stand. So I would suggest that you could find that at that point, the defendant hasn't shown prejudice, because more than likely Attorney Yannetti would not want to go down this road of having a trial.
He doesn't know what she's going to do. So you immunize her, right? Now he has some kind of, presumably under Brady or something, you're going to find out when you immunize her what she has to say. You may want to call her, right? So then he's going to find out before trial what she says, and then he's going to decide, do I call her or do I not? This is what she would say, right?
Yes, and I think I know you found it because he didn't talk to her at that point, but I think you can still go back to the reasons he stated in his affidavit why he initially was not going to call her. His strategic reasons was the hostile relationship. He didn't find her testimony particularly useful. He found there was a lot about the cross-examination that came out. And now you're going to add that she's now claiming a fifth, and the Commonwealth's going to put her on the stand to presumably say, well, we know from Judge Run that she's going to testify that I lied during the first trial. I think a reasonable attorney would not want to go forward on that basis. And therefore, as such, the defendant would not have been deprived of a substantial ground of defense, because now you're going to have a sympathetic witness the Commonwealth's going to call to say, yeah, I lied during the first trial, and here's the reasons why. And given putting in her testimony that was already, and for the reasons stated why he was hesitant to do that, I would suggest that would be manifestly unreasonable to do that. So therefore, the defendant hasn't shown that he's been deprived of an otherwise substantial ground of defense. If there's no further questions, the Commonwealth will rest on its brief.
I see no further questions. Thank you very much. Good arguments, both of you. The case is submitted.
Thank you.